voy a decir nada.
Sí. ¿Dónde está puesto el...?
Decana está aquí, porque la decana preside aquí en medio y tú vas hacia el otro lado. Entonces, si os podéis mover. Vosotras dos estáis en el centro. Monse, ¿te puedes mover uno más hacia allá?
Sí, claro, me muevo a donde...
A donde digáis.
Yo donde me digáis.
Yo también.
Sí, aquí, por
Coge
favor.
la otra silla. Coge la otra.
Esto lo pongo.
Ah, perdóname.
No, eso sí está.
Sí. Sí, es chulo, ¿verdad? Todavía.
Good morning, Professor Cristina, it's online, dears Encarnación, Monse, and Laura are here with me. Thank you very much for inviting me to this presentation of this international symposium. It's a pleasure as a Dean of the School of Law and Social Science of this university to be here. I want to welcome all the attendees here in person and online here today. This seminar is, for me, a good example of the kind of events that the Deans of a School of Law wants to support. It focuses on a topic on extraordinary and unquestionable importance, environmental law. Moreover, it perfectly fits in the calendar as we all still have in mind the last COP28 now in these days. Well, usually I like to talk about the two main challenges we face as a society. One, on the one hand, to limit global warming, to fight climate change, and on the other hand, to achieve sustainable development. When we know about sustainable development, we are concerned to an economic development that can satisfy our current needs, but doesn't compromise the planet for future generations. This economic growth must be inclusive, without inequalities and without negative impacts on the environment. The strategies that countries need to address to address this challenge involve a deep transformation for the economy, the most famous of which is the well-known energy transition to a decarbonized economy. States, governments, regulators are called upon to promote policies and laws that guide the international community in this challenge. I'm sure one of the best places to reflect on the legal framework that we need in this process of transformation is the academic world, the universities, with symposiums like this. The commitment not only with the environment but with sustainable in a broad sense and the sustainable development goals is already an imperative for companies and institutions. University Carlos III of Madrid is aware of this and is committed to integrating the SDG agenda in the different areas of actions of the university in order to contribute to achieve the goals and targets agreed in the United Nations. I'm going to finish this speech, but not before reiterating again my welcome to all of you. All of you, I'm sure that you will enjoy this symposium. Thank you very much, and now I am going to give the floor to Encarnación Roca Trias, Vice President Emeritus of the Spanish Constitutional Court, partner Cremades and Calvo Sotelo. Thank you, Encarnación. Yo creo que está. Sí, sí. No te...
Thank you. And thank you for the invitation to participate in this opening session in this important symposium organized by the University Carlos III de Madrid and supported by the World Law Foundation as part of its program on the protection of the expansion of the rule of law. Spain has a rule in its constitution that recognizes the right of citizens to enjoy an adequate environment. This right is not protected by the remedy of amparo, but it obliges legislators, judges, and public authorities to recognize, respect, and protect the law and to act in accordance with it. Consequently, public authorities are obliged to use environment resources to improve the quality of life of citizens and the maintenance of the quality of the environment. But at the same time, both public administrations and citizens have a duty to conserve this environment. The environment is not a juridical person, as might consider those currents of thought that personify what they call the Pachamama. For instance, in the Constitution of Ecuador establishes this protection and name it the Pachamama. Those who have the right and duty to preserve are both citizens and public authorities. It is a community without borders that will only protect itself by establishing rights and duties aimed at conserving our environment. How and in what form the environment must be preserved, I have to leave to the presentations and interventions that will take place in this symposium. It only remains for me to hope that these days will offer effective and useful solutions to make the right a reality. And I have no doubt about this in view of the quality of the rapporteurs. Thank you very much, and I assure you a great success.
Thank you, Encarna. Now is the turn to Cristina Boyd. Cristina is the chair of the UCN Work Commission on Environmental Law, co-chair of the Paris Agreement Implementation of the Compliance Committee, full professor of Public International Law, University of Oslo, Norway. Cristina, it's your turn.
Thank you, and good morning. Can you hear me?
Yes, Cristina.
Thank you so much. I would like to briefly start with a very warm welcome as well to this fantastic symposium on investigating the legal role of law in creating a system that is in harmony and peace with nature. It is a big task, and I'm very much looking forward to hearing many of the interventions today. But before we get there, I would first and foremost like to thank Professor Montserrat Abad-Castellos for organizing this wonderful symposium. She is really a force of nature. It's not that long ago that we had a similar symposium on ecocide, and I'm really glad that the IUCN World Commission on Environmental Law is able to work together with her and her team and the Universidad Carlos III de Madrid and many other partners, UNEP, ICEL, and the World Jurist Association in organizing and carrying out these very important events. Now, the time for a symposium like this could not be more pertinent, and as we already heard from the previous brief interventions, we do live in unprecedented times. We live in unprecedented times. We do know that the tasks ahead of us are bigger than anything that has ever been done before. In order to address climate change, to address biodiversity loss, to address global pollution and injustice worldwide, what we need to see is a complete transformation of all sectors and systems in a very short period of time. And that is something that is unprecedented in scope, scale, and speed. And in these changes, in which the law will have to play a significant, a crucial role, we need to see changes on so many different levels and on so many different issues. We need to see changes that take into account the differences in this world, the differences between those that have caused the pollution, have caused the problem in the first place, but also differences between those that are most exposed to the consequences, to the impacts of pollution, that in many cases are not the same, whether on a level of states or communities or villages or individuals. We also need to see a legal system that protects those that do not have a voice in our elaborations of justice, for example, the natural environment, or that do not have a vote, like children or future generations. So we are faced with changes that are so profound and need to reflect significant rethinking about the rule of law, about the role of law in this endeavor. Now, we see that many lawyers worldwide, lawyers, legal academics, judges, are already thinking about many different tools and how they can be applied, and some of them are already being deployed. And we heard about rights of nature already, or the rule of law, the environmental rule of law, or how to implement effectively a right to a clean, healthy, and sustainable environment, or to protect rights in an intertemporal context, or even the crime of ecocide that I just mentioned. These are fairly new and innovative ideas. They have been around for a while, but they're gaining legal currency as we speak, and we need those tools in order to be able to have a full toolbox to address the challenges ahead of us. And there might be more, and I'm sure the symposium will offer some additional thoughts and ideas. These unprecedented times are a huge opportunity for lawyers, for legal scholars, for judges to use their profession, to use their expertise to the best of their abilities. But they're also a time of responsibility. I think it is the responsibility of every lawyer, of every member of the legal profession to deploy their knowledge and their expertise to the best of their abilities in harmony and peace with nature. And I thank you so much and give the floor back to Madrid.
Thank you very much, Cristina. Now it's the turn of Montserrat. Montserrat Abad is full professor of public international law at the Universidad Carlos III of Madrid, co-director of the ICEL's International Secretariat, co-principal investigator of the project Making Peace with Nature and Making Nature a Key for Peace.
Thank you very much. Hello, everyone. It is a privilege for me to intervene in this first panel to welcome you all to this event. I would like to thank, on behalf of the organizing team, to many colleagues and entities who have essentially contributed to make this symposium possible. First, to our scientific committee's members. Second, to the Dean of the School of Law and Social Sciences, and as well as the Vice Rectorate for Research Policy of Carlos III for their grants. Third, to our partners, the Global Judicial Institute on the Environment, the IUCN World Commission on Environmental Law, the UNEP's Law Division, and the World Jurist Association. And last but not least, we express all our gratitude as well to the speakers and attendees both in person and online. To all of you, many thanks for your generous support and collaboration that we deeply appreciate. This event has been convened in the framework of the Pax Natura research project granted by the Spanish Ministry of Science and Innovation for the 4 years ahead. Pax Natura is the acronym for Nature, Conflict and Cooperation, the transformative power of law over actors, resources, spaces, behaviors, and harm. Pax Natura is composed of 2 parts. On the one hand, the first part's main aim is to contribute to make peace with nature and make nature a key for peace as well. And on the other hand, the second part's major goal is to help bring justice to make peace with nature, focusing on the judicialization and other forms of jurisdictional and institutional protection of nature. Well, this 2-day symposium deals with several hot issues, bringing together scholars, legal practitioners, and civil society leaders to debate on topics that lie at the interface between nature and natural resources, justice, and peace. Everyone has a role to play. In the words of Jane Goodall, yes, the British primatologist, we can have a world of peace. We can move toward a world where we live in harmony with nature, where we live in harmony with each other, no matter what nation we come from, no matter what our religion, no matter what our culture. This is where we are moving towards. This implies to advocate for a more equal, just, equitable, and healthy world. For that, harder law is needed, as well as better application of the existing norms. It is necessary more sensitivity, both thinking as society and individually. It is urgent to work more and better. This decade is crucial and the time to act is now. Again, thanks to all and welcome.
Thank you, Rosa. To conclude with the intervention, I'm going to give the floor to Laura. Laura is Dean of the Faculty of International Relations and full professor of private international law at University of Vigo. Co-principal investigation of the project Making Justice to Make Peace with Nature, the again, Laura is the Dean of the Laura is the Dean of the Faculty of International Relations and full professor of private international law at University of Vigo. Co-principal investigation of the project Making Justice to Make Peace with Nature, the judicialization and other forms of jurisdictional and institutional protection of the nature. Laura, this moment.
Thank you so much, Rosa. Thank you so much for having me here in this excellent company. I will very much join all the things that Monse has already delivered, so I'm not going to repeat all the list, but I think it is justice, and going back to the title of my project, to give a special thanks to Monse, which is the real architect of the whole program, of the reason why we are all here today, and has put a lot of effort onto this wonderful program that actually reflects quite a number of the objectives that we have in these 2 ambitious projects. The project that the University of Vigo is leading is going to address, or to try to address, because it's very complicated, taking into account the polyedric approaches, the polyedric, I mean, it is about our whole lives that's going on, that has to be at the stake in this whole endeavor of bringing sustainability to, making real sustainability to our world, that is taking very broad picture about all the topics, and we at the University of Vigo, we will try to address these topics from a bottom-up approach, going to the grassroots movements, and the way how strategic litigation is actually evolving at different levels. So you can see in the program, especially in the tomorrow, that we are going to address strategic litigation at national level. So we have a team of administrative lawyers. We would like to very much thank to them for joining us. Then we have a team of international lawyers, second panel. We will be addressing, and it's the same more or less at the first day, we'll be addressing the strategic litigation at international level, and last but not the least, we will be addressing the environmental sustainability from a private international law perspective. The main idea of this project is not to study all these matters in a separate manner. We like very much here in Spain labels, and more or less is the same in other countries, but the idea of the project is to bring all this knowledge together and try to see the synergies among the different fields and really go beyond a separate approach and learning how, in reality, all these movements are feeding to each other and helping to establish not only clear boundaries or clear obligations towards states, but also towards other actors, including, of course, businesses, but not only that, as was already mentioned here by Professor Roca, is also about the civil society. We also have obligations. So thank you so much, everybody, for being here. It's a pleasure, and I hope that these 2 days are going to be very fruitful and full of interesting thoughts that all we can learn and bring back to our own research. Many thanks. Thank you, Rosa.
Thank you, Laura. Then we are finished the presentation. The Congress is inaugurated. I hope you will enjoy the 2 days here and your stay at University Carlos III. Thank you very much.
Thank you very much. May I ask one question?
Yes.
That the real architect of the program was Professor Robinson, the executive president of ICEL, the International Council of Environmental Law, because he primarily designed all the first the major lines of the project. We had to make unavoidable slight changes, but he's is the real architect.
Thank you, Professor.
Yeah.
Okay, good morning, ladies and gentlemen. We are exemplary, close to the Swiss. We are even ahead from schedule. It's 9:29. We are punctual, even more than punctual. I'm very happy to chair this table. My name is Ángel Manuel Moreno. I am a full professor of administrative and environmental law in this university where I have been working for more than 30 years already. This panel is supposed to talk about a very important subject, strengthening environmental rule of law. This is very, very interesting, as I will say, I will explain later. We have 4 speakers on the program. Unfortunately, one of them is late, probably has been suffering the traffic jams of Madrid. He will arrive soon, I think. One of the speakers will do her presentation online, Professor Patricia Cameri-Bote, and the 2 other people are sitting here, Mr. Diego Solana and Mr. Triantafilos Cubas. Okay. So this panel, this opening panel is very interesting. We are talking about strengthening environmental rule of law. Well, what does it mean? We expect that the speakers will illuminate this concept. Rule of law is a very murky concept. Can be translated into different ways in Spanish. Principio de legalidad, Estado de Derecho. So there are many translations and different conceptual understanding. This topic is probably very pertinent today in Spain, where it is arguable whether we are complying really with the rule of law standard. It has been discussed by some people, even in international forums. If we add the adverb or the adjective environmental to this construct, it is even more difficult. So what is environmental rule of law? So this is what the speakers are supposed to clarify with their illuminating presentations. They will speak for 11 minutes. All the chairs have received very clear instructions from the organizers that our main and probably only duty is to keep the speakers under control, so they don't speak more than they are supposed to speak. That is a traditional Spanish habit. And following the rules of soccer or football, I will show a yellow card to the speakers when you have 2 minutes, and then the red card when the time is over. I do that for the benefit of the symposium and for the interest to having a short debate after these presentations. So I'm very honored to give the floor now to Professor Patricia Cameri-Botte. This person, you know, is a very prominent scholar in environmental law. Currently, she's the director of the Law Division of the United Nations Environment Program. And apart from that, she is a full professor at the School of Law at the University of Nairobi in Kenya. So I don't know whether she managed to go through the digital.
For now, the screen.
No screen?
There's no transmission. As
No.
we speak.
Houston, we have a problem.
I seem to be online.
Good morning, Patricia.
Morning.
Did you hear what I said before?
Yes, I did.
Okay. So we are very honored to have you with us today. Thanks for the effort. I don't know what time is it now in Kenya, but probably not so good time for speaking like here. So you have the floor, and please keep your presentation in 10, 11 minutes, please. Thank you.
Okay. Thank you, Chair. It's indeed my great honor and pleasure to speak at this august gathering. And I think the discussion that we're having today on the importance of environmental rule of law in addressing the environmental crisis that we face and looking at how we promote good environmental governance is timely, just coming out of COP28. It is also timely as UNEP's second global report on environmental rule of law, entitled Environmental Rule of Law, Tracking Progress and Charting Future Directions, was released just a few weeks ago. This report is the result of years of work by many colleagues, leading authors and institutions, including many of you present here today. I thank you all for your support and contribution. While the rule of law in its traditional rendition seeks to deal with the excesses of those with power as they deal with those without power, environmental rule of law adds an additional lens to the checks by addressing excesses of the powerful over nature, which also affect the less powerful who depend on nature for their livelihoods. While I hope you get a chance to use the report as a resource material in the coming years, today I will present some of the key findings and trends identified in the report regarding the role of civil society, public interest lawyers, and courts. My first key message relates to civil society. Civic engagement supports environmental rule of law in several ways. By taking stakeholder knowledge and interest into account, new policies are perceived as more legitimate and better tailored for effective implementation, leading to increased compliance rates. Involving the public in environmental governance raises awareness about environmental threats and helps entities and individuals understand the legal requirements they must comply with, which enhances accountability for both governments and private corporations. 4 key global trends have impacted civic engagements and the environmental rule of law since the first global report on the environmental rule of law was published in 2019. The first one is the COVID-19 pandemic, which reduced the capacity of NGOs and governments to engage communities in their work. Despite the great potential of digital instruments, the forced reduction in engagement levels combined with the devastating economic and health outcomes of the pandemic had an overall negative impact on civic engagement, including in environmental issues. Secondly, digitalization of civic engagement had positive and negative impacts. The standardization of virtual platforms allowed for an expansion in engagement levels on the one hand, but gave rise to digital security concerns and digital divide challenges on the other. Racial and social justice movements and protests have driven engagements on environmental justice issues worldwide. At the same time, environmental groups have increasingly incorporated racial and social justice issues into their work. Fourthly, environmental human rights defenders continue to be at risk. Between 2012 and 2021, at least 1,733 environmental defenders from 61 countries were murdered, an average of a killing nearly every 2 days, according to the Global Witness Report 2022. In 2021 alone, 200 environmental defenders were killed globally. My second key message relates to public interest lawyers. In many systems, substantive and/or procedural obstacles prevent public interest lawyers from performing their key role in advancing environmental rule of law. The report identified that a growing number of countries have been introducing specific solutions and instruments to mitigate these problems. One way to do so is by allowing broader or completely open standing in environmental cases, granting legal persons who have not been directly affected the possibility to bring an action to protect the environment. As of 2021, at least 41 states have adopted laws or procedures that provide for open standing in environmental cases. In many instances, such provisions are part of framework environmental statutes. In others, open standing is provided for in constitutions or established through judicial precedent and/or court rules. Another barrier to access to justice in environmental issues is the loser pays principle. Requiring the losing party to bear the economic burden of the entire dispute can discourage less affluent groups from filing cases, despite often being the most likely victims of environmental harm. It also makes it harder for public interest lawyers and NGOs to use litigation as a tool to hold powerful actors accountable. According to UNEP's second Environmental Rule of Law report, 128 countries apply the loser pays principles as the default rule in environmental cases as of 2021. Many jurisdictions have started loosening the loser pays principles in particular situations, especially the presence of good faith and a clear public interest. Ensuring that all legal professionals, including public interest lawyers, receive sufficient training in environmental law is crucial to grant victims or potential victims the possibility to see their interests effectively defended in court. 9 countries have made environmental law a mandatory component of legal training. This requirement appears either as a specific legislative or regulatory requirement, listing environmental law as a mandatory component of legal education, or as a general law which requires environmental issues to form part of vocational training at all levels of the national education system. The third key message relates to courts. A well-functioning justice system is one of the primary mechanisms for enforcement of environmental law, as it can deter future violators, improve compliance, and create a measure of accountability for other branches of government. 4 global trends have affected courts in environmental matters recently. After initially making in-person proceedings problematic, the COVID-19 pandemic forced courts to rapidly adopt measures to adapt their procedures and infrastructure, thus accelerating the digitalization of judicial systems around the world. Judicial action on climate change has been growing globally at an unprecedented pace, especially to remedy executive and legislative inaction on the topic. These cases are usually based on constitutional rights, human rights, including rights of future generations, and administrative law. The nature and number of remedies provided by courts in environmental cases have expanded significantly over the years, including orders of restoration for environmental harm, symbolic compensation, and declaratory judgments, and the establishment of programs to educate the public. Due to the inherently transboundary nature of many environmental issues, judges are becoming more open to granting remedies to plaintiffs who have suffered environmental damage caused by foreign entities domiciled within their jurisdiction. In particular, courts are increasingly imposing liability on parent companies for harm caused by their subsidiaries abroad. Judicial training and several initiatives to share information and enhance capacity to ensure effective implementation and enforcement of environmental law have been launched globally. As of 2020, at least 39 countries have a judicial training institute at the national or subnational level that included environmental law in its judicial training activities. UNEP has supported judiciaries across the world, including through supporting the Global Judicial Institute of the Environment. Many countries have created specialized environmental courts and tribunals or environmental benches within existing courts. Following an initial rapid increase in the number of environmental courts and tribunals, they have grown at a steady pace in recent years, reaching over 2,116 environmental courts in 67 countries by 2021. And we are not counting here countries that have actually very many environmental courts and tribunals because of their vast size, such as China. They can take various forms based on the specific needs and context of each country. Recent trends among environmental courts and tribunals include the growth of green benches with judges trained in environmental law, amalgamation of several institutions into one, and a more incremental progressive approach to establishing environmental protections as opposed to drastic, immediate, broad changes. In conclusion, in the face of the environmental crisis that we face, environmental rule of law has never been more important or relevant. Environmental rule of law provides an essential toolbox of approaches for strengthening the implementation and enforcement of and compliance with environmental law. The roles of civil society, public interest lawyers, and courts are more important than ever to ensure environmental justice. I think I'd be remiss if I didn't say that the Legal Academy also has a role and in the implementation of the environmental rule of law. And this has been identified in UNEP's second Global Rule of Law report. As new challenges and opportunities arise, often intersecting, UNEP will continue to support the efforts of these key actors in environmental rule of law. I thank you and look forward to a most engaging symposium. And I do hope that you will all get an opportunity to read the full report, which is online. Thank you.
Thank you very much. Thank you very much, Professor, not only for your very illuminating presentation, but by the fact that you respected correctly the time limit. Thank you very much. You mentioned many important aspects of this environmental rule of law, and you provided very interesting figures. As I was reading or taking notes, I was wondering whether Spain, or how Spain qualifies in this scale, because we have not heard of environmental defenders being murdered or killed in Spain yet. But the other requirements, I'm sorry to say that we fail. Access to justice in the administrative courts, we have the loser pays principle. So if you bring a claim against the government and you lose your case, you will be condemned to pay for the costs. Environmental law is not a mandatory course in law schools in Spain, and it's not a mandatory course in Carlos III University either. And what about judicial training? Well, you know that Spanish judges must pass a very hard examination. This is called the traditional oposiciones, and I don't know whether there are some subjects of environmental law. So I hope that the other speakers have another idea during the debate. So now let's go to the second speaker, Mr. Diego Solana. He is Diego Solana, he is the international advisor of the World Law Foundation, and he's also a partner at a very prominent law firm in Spain, the law firm of Cremades and Calvo Sotelo. So you have the word. You have the floor, sorry.
Thank you very much. Thank you very much, Professor Moreno. I promise to stick to my timing. I hope that you don't have to warn me with any sort of
Cards.
Cards, yes. Well, good morning, everybody. Yes, briefly, at the World Jurist Association, what we basically do is we promote peace through law, and we promote the rule of law as the only alternative to a rule of force. And we understand that the rule of law is the best tool invented so far by civilization in order to resolve mainly international disputes. And that is how peace is promoted, instead of through conflict or through war. But the rule of law is not only a tool used in the international disputes, but it's also a basic tool for citizens, for corporations, for institutions to resolve any sort of controversy. And it is strongly linked also to our, I would say, common global goals regarding environment and sustainability. So there's a very strong link between sustainability and the challenges that we are facing and that previous speakers were referring to. And I'm sure that in the future, during these 2 very interesting days, will also will come up. So rule of law is also very important issue. But when we talk about the rule of law, I would say that it's very important to understand, or at least to define, to have a common ground on what really is rule of law, no? And at least from the World Jurist Association and from the people that we discuss about this very strong concept, that it really connects us with the Greeks and the Romans several centuries ago. We understand that it has to be anthropocentric. And what do I mean by this? Is that rule of law is not only formality, is not only a procedural that allows you to enact or to pass a particular law. It has to be based on human dignity. Human dignity is a value in itself. And if you pass a law, or if you enact a particularly regulation that confronts directly to human dignity, in my view, we are not talking about rule of law. Unfortunately, there are plenty of examples in history where human dignity has been really confronted, even though apparently the formality of approving a law or the legal procedure was fulfilled. So that will be my first comment. And I would like to also quote Immanuel Kant, who was one of the first who said that human dignity is a value in itself. And if we are using human dignity for a different, or we are using humans for a different goal, we are really infringing that concept of human dignity. And also, this concept of human dignity is really the root of where our political freedoms, our individual rights come from. So rule of law is very important in order to live in a political and a society community. During the First World Law Congress, it took place in 1963 in Athens, organized by the World Jurist Association. Chief Justice of the United States Supreme Court referred to, my understanding, a very, very important quote also. No? He was saying that there is still hope in the world. We were living there during the Cold War years, so really, truly, the total annihilation of the war was a real potential possibility. No? So when he was referring to all the Chief Justices that were gathering there at the World Law Congress, he was saying that there is still hope for freedom and for peace in the world if, and only if, we are ruled by law, and we are not ruled by political parties, we are not ruled by force, we are not ruled by an ideology, but we are ruled by law. So it's very, very important to try to remember what's the rule of law and why it's so important to us. No? 60 years later of that First World Law Congress, on July 2023, we were really honored to co-organize the World Law Congress with our friends of ICEL. Here is Montserrat Abad, that she had a very, very prominent role, and other colleagues that Teresa Parejo or Victor Tarfur were there. Also, thanks to the Global Judicial Institute on the Environmental, that they are also organizing this these 2 days of discussion. We had the opportunity to listen to Antonio Benjamin, the chair of this organization, and also Jose Igreja Matos, the president of the International Association of Judges. So we were truly honored to have them here, and thankfully you extend that also an invitation to participate in these 2 days of discussion. Last October, a delegation of the World Jurists Association went to the Dominican Republic and went particularly to Santo Domingo. We visited there the president of the Dominican Republic, Abinader. We had a very fruitful conversation with the president of the Supreme Court, Henry Molina, with the president of the Congress, with the president of the Senate, and we finally decided that the next World Law Congress that is going to take place on May 2025 is going, the venue is going to be Santo Domingo. Santo Domingo will become, as it did in New York some months ago, the international legal capital of the world for 1 week. I hope that ICEL and all the organizations that are here come with us, because truly the conversation about environmental law and rule of law there were very interesting, and everybody was extremely satisfied with your engagement. So I hope that we all see you there. Thank you very much for the organizers, and thank you, Professor Moreno, for moderating this roundtable.
Thank you very much. Well, you have respected very well the time limit.
Well, you warned us.
No, but I haven't. You were supposed to speak longer, but you will have the opportunity now.
So I can abuse my time.
Yes, probably. Okay, so it has been said that the rule of law is a government by the laws and not by men. Other people have said the government by people, for the people. The different approaches. But it is true that that the rule of law is a government which is bound by the law, and the law is a large concept encompassing not only acts and statutes, but also judicial case law and principles. That is, and environmental law is very rich in principles, probably more than any other field of law. Principles are good, but principles may be also tricky, because we don't know what they mean, or they can be open to different interpretations. So your presentation is very pertinent. I'm happy to introduce Dr. Triantafilos Kouvas, who is a postdoctoral research fellow in legal philosophy here in Carlos III University. And we'll address a difficult question, which is prevention and precaution as legal principles. And I say this is very difficult because those principles are sometimes confused, and there are strong connections too. So I'm happy and eager to see how you are distinguishing those principles. You have the floor.
Thank you very much. I think it eventually should become the job of a philosopher or philosophers to try to bring some conceptual clarity with respect to certain distinctions. So the way I would like to start is actually take the thread from Diego's presentation and more specifically about this idea of the rule of law and being governed by legal norms or legal rules or legal principles, of course. And I would like to combine that idea with something that really triggered my attention, and this is the title of today's symposium, which is Towards a Legal System in Harmony and Peace with Nature. Well, I don't know whether this is a coincidence, but that brought me back to the Stoic philosopher, Zeno of Kitio, who he actually talked about first time about the importance of living in harmony with nature, right? So the Greek version was homologumenos te phusei sden, which means to live in accordance with nature. And I think this is an interesting case. In which sense? Well, usually we associate the rule of law as a concept, obviously, with the concept of governance by legal norms, and further, with the idea that legal norms govern actions, right? But here we're talking about also living in accordance with nature. Living and acting are not the same kind of concepts. And if you broaden the perspective of different kinds of conduct or behavior, I would tell you that from a philosophical, moral, or philosophy of action point of view, there are at least 3 dimensions with respect to which we can ask questions that also matter for environmental law. And this is, what kind of persons would we like to be? So, who to be? 2, what should we do? And finally, how should we live? Now, intuitively, and at least from a first approach, law doesn't seem to be the kind of concept or apparatus that is more well fitted to tell us how to live. Even though I have the impression that, especially in the case of environmental law, law should also have something to say about rules, principles, norms that should also at least partly guide the way we live, because without remodulating the way we live, I don't think that our concerns about the environment will be properly addressed, at least in the long term, right? So, with that being said, and given the fact that obviously I'm not an expert in environmental law, I'm a legal philosopher, I was very much intrigued. I was reading a few things about recent debates about these concepts, and the first thing that came to my mind, of course, is that all this already harkens back to the German sociologists and Luhmann and the idea that we live in a society of risk, right? So environmental law is all about legal responses to risk. But then there is also a forgotten discussion about the very nature of risk. Why? Because there are always 2 adjacent neighboring concepts that are not usually being addressed at the same level of abstraction as the concept of risk in environmental law. And these are the concepts of threat and the concept of danger. So that's the first thing I would like to draw your attention to. So we can also talk about environmental threats, right? Environmental risks, but also environmental dangers. And one question is, how can we distinguish between these 3 concepts in a principal way, and whether our legal responses to these 3 concepts would be different precisely because these concepts are different, right? So in very brief terms, the idea is that threats somehow also involve some kind of malicious intention behind them, right? So there's a dimension of targeting. Then risks, which is the most common concept, does not necessarily imply any malicious conduct or intention, even though it can cause harm, of course, right? And then danger. This is actually what brings me back to the Stoic philosophy, because the Stoics didn't also only talk about the importance of living in harmony with nature. They also drew this distinction between things that are under our own control, ta ephimin, as they called it, and things that are beyond our control, ta ephimin, that are up to us, right? And I think that danger is precisely this idea that certain things are not up to us. But that doesn't mean that our action becomes irrelevant, right? Even when things are not up to us, maybe because we are very controlling beings as a species, right? We still need to do something, right? And I think that there's also a dimension there that needs to be discussed. If you ask me, I would tell you, for example, that the principle, and this is not a principle that I included in my presentation, which is the principle of due diligence, right? It's not the principle of prevention, it's not the principle of precaution, it's the principle of due diligence, even though in the doctrine I see that these sometimes are conflated. I think that the principle of due diligence goes closer to this idea of tackling also with danger, because it is precisely the diligent state of mind that is the only way you can deal with things that you cannot measure, for example, in the case of risk, or with things that you cannot protect yourself from, as in the case of threats, right? Am I doing well in terms of time?
Yes.
Okay,
You
all
have
good.
7 minutes.
Oh, good, nice. So that's one distinction that I'd like to draw your attention to. Now, another distinction. And please enlighten me on that, you international lawyers, right? I know that it's almost common consensus that in international law, the main type of obligation are obligations of conduct as opposed to obligations of result, right? It's not that there are no obligations of result, but the tendency is not to be so demanding of people and states, of course. I mean, in the case of international law, it's mainly states, obviously, and perhaps, concomitantly companies also and non-state actors. But then again, I think that this distinction is incomplete. Why? Because we have one poor neighbor to these 2 concepts that is always being forgotten within the legal discussion, but is never forgotten in the moral discussion. In the moral discussion, we have a distinction between three types of obligations. Indeed, we have obligations of conduct, we have obligations of outcome or result, but we also have what we call obligations of role obligations. So, for example, obligations that are attached to specific positions we occupy within a social arrangement, right? So it can be as ordinary as the obligation of parents versus their children, or it can also be certain obligations of state officials, for example, linked to certain statuses, or it can even be the obligations of a train conductor, for example. All these are role obligations. And again, if you ask a philosopher about whether these three types of obligations are more or less the same and that we can really, move back and forth, most would actually, they would balk at this kind of move, especially because they imply very different understandings of how we conceptualize action, right? It is one thing, for example, to understand action, and in our case would be, for example, preventive action, right? As a kind of manifesting a role, right? Why? Because if you focus on the role side of obligations, not the conduct, not the outcome, then action acquires a flavor that you will not find in the other two. And you know which flavor this is? Action becomes a little bit like a performance. You can ask questions like, has someone performed their role well? In the same way would we evaluate the performance of an actor, for example. So action is performative in the context of role obligations in a way that is definitely not performative, for example, when we're talking about obligations of outcome. Obligations of outcome are simply about making sure that certain things either happen or don't happen, right? So the only standard of evaluation, the standard of success, right, is figuring out whether the so-called outcome has obtained or not. And also in the case of conduct, even if, for example, you are not diligent, but nonetheless you behave in a way that fits the description of a specific duty of conduct, that's fine, right? There's nothing wrong there, right? So that's the second, let's say, triptych or tripartite distinction that I would like to draw your attention to. Obviously, the third one is the one I implied before, which is the one between the three principles of prevention, precaution, and due diligence. And with that, and I presume I have like 3 minutes more, like 4, 3,
Yes,
3?
3 minutes.
3 minutes.
Just wait for the yellow card.
Okay, I'm a
Not
bit
yet.
afraid of that
Not
card. Okay, so just very briefly, again, as I read, I didn't know that, I'm learning. I know that there is an ongoing discussion, for example, about the legal status of the principle of precaution. So there is a discussion I read regarding its status as a principle of international customary law, for example. It seems that this is not a disagreement with respect to the principle of prevention. But that being said, I would like to say a few things about how these are usually distinguished in the doctrine, right? So in the doctrine, usually these two principles are distinguished with how we understand risk. As a philosopher, I have an objection to that because, as I told you, it's not just about risk, it's also about threats and dangers, and I think that risk is being treated in a very inflationary way. They're trying to push everything into the concept of risk. But let's suppose it is risk, right? So the idea is that we distinguish between two types of risks, so known risks and hypothetical potential risks. So the idea is that the principle of prevention applies to known risks, something that can be measured, and accordingly you can take very specific measures, very nice. And finally, in the case of unknown or uncertain risks or potentialities, this is where the principle of precaution kicks in. Usually the kind of verbs that are being used in that context are actions like mitigation, avoidance, minimization of harm, right? So it seems like that the relationship between these two principles at the level of international legal doctrine is being treated as a matter of spectrum, right? Such that as we fade from the measured to the less measured to the unmeasurable in terms of risk, we fade from a preventive approach to a precautionary approach, right, to environmental harm. And just one last sentence. I think that, again, we are missing one more word that doesn't appear at this level. So we have precaution, we have prevention, but what about protection? I don't see that word being used that often unless at a very general level, such as the protection of the environment. What about protection as a form of action, right? And I think, again, the concept of protection brings us back to the concept of due diligence. So protection always takes place under a specific state of mind, the diligent as opposed to the negligent state of mind. But we could leave that to the discussion. Thank you so much for your time. Thank you.
Thank you very much. So thank you very much, Dr. Cubas. I can't resist to take my role of chair to reply a little bit or to expand or to react to what you said, because this topic is very keen to me because I have worked on this and have published. For instance, if you want to have general legal framework, for instance, the Treaty on the Functioning of the European Union, Article 191, when it specifies the principles that will be followed by the Union while protecting the environment, it distinguishes between preventive action, not said prevention, but preventive action, and precaution. Okay. So preventive action and precaution are principles that apply to the governmental level when they frame public policies. But they work in different frameworks. For instance, with the principle of preventive action, we know the environmental harm, and we act before in order to avoid or to minimize the environmental harm. For instance, you are industrial installation, and we are imposing on you the duty to have an authorization, and we are limiting the amount of pollution that you are supposed to release to the air or to the water.
Emission limits.
Emission limit, yeah.
This is an obligation of outcome, by the way.
Okay. Another example is when we know that atmospheric pollution comes from different sources. For instance, there is too much lead in the air, and some of the lead is introduced by combustion engines. So we minimize or we reduce or we phase out lead in gasoline. So we prevent the harm, but we know. While precaution works in a context of doubt. We think that there is a problem, but we are not sure. We don't know at 100%. For instance, to which extent a new project is going to harm the habitat of a species that lives in a forest that is going to be cut to another two. So we perform a protocol to find out by an environmental impact assessment and to take the necessary measures. Another example is the REACH regulation, the 2007 REACH, it's a big norm approved by the Union regulating the trade and the marketing of chemicals. So if you're a company and wants to market a new chemical, you need to register your substance in a new agency based in Helsinki, which is ECHA, Environmental European Chemicals Agency. So if the agency believes that your substance may have a harm on the environment, they are authorized to require you to make tests to unveil this doubt. But I don't agree with you that these two principles are in the same level as due diligence, because these two principles apply to public policies, but due diligence are applied to individuals. Only. So the government is not supposed to demonstrate due diligence. So only individuals have to prove to the government that they took all the necessary measures, and then you have different standards of liability, full liability, objective liability, and so on. But this is just food for thought. Yes, okay. Well, so I'm very happy that all the speakers respected the time limits, and you have the floor now. I'm sure that these very good presentations trigger a lot of questions. If you want to ask any question, please raise your hand and say your name in loud voice. I'm sure that there are many questions, but you hesitate because it's very cold. It's 9:30. Caffeine is at its lowest concentration in the bloodstream.
Could I share a thought with you,
Yes, please.
Just in case
Yes.
to stimulate the discussion? So the thing you said about the principle of due diligence, so I have no doubt that this is how the doctrine conceptualizes the notion of due diligence, and it absolutely makes sense. But then the thing is that if you associate the concept of due diligence with what I call obligations of role, right? So in terms of how well you perform with respect to, so how diligently, let's say, you perform a specific role, then there's no conceptual barrier to understanding, for example, certain state offices as institutional roles, right? I know this is not the doctrine, by the way. This is an extra doctrinal or extra, if you like, jurisprudential approach to the topic. It's just that I don't think that there is a conceptual barrier to applying standards of diligence, if you like, to state officials under one, of course, presupposition, right? First of all, it's not just the state as an abstract entity. You really have to understand the state as an agglomeration of roles. And of course, you also need to give a very specific descriptions of the roles and the tasks that are associated with the roles. So, of course, that is not obvious, right? Absolutely. But this is the idea that I had in mind.
Yeah, it is also possible that this problem can be addressed in different ways by legal philosophy as a matter and a normative context. Okay, so who wants to take the floor? No one? Please, say your name and ask your question to the speaker you want.
As a developed state or a state in development. So we can talk, I don't know if we can talk about a role of obligations of industrialized states against non-industrialized states, because that's something it reminds me of. And also about the rule of law, my thesis is about the creation of an international environmental code. I don't know if the UNEP has taken some serious steps forward to the creation of this code, because I think the rule of law in any international system that is serious, like the criminal international system, which has the International Criminal Court, the environmental international system should have an international court, which brings states, multinationals, enterprises, and also individuals to justice. I don't know if you could give me an opinion, and if there's going to be any step in the future forward.
Thank you. Before I give the floor to the speakers, may you allow me to say a couple of things. First, concerning your first question, maybe you are addressing the principle of common but differentiated responsibilities, which is a well-established principle in international environmental law, by which some countries are required to do more than others because they did not contribute to the same extent to the problem. This is clearly seen in the Kyoto Protocol, where there were Annex I countries that were obliged to make reductions, and non-Annex I countries which were not obliged to do reductions. Concerning the International Environmental Court, personally, I am skeptical about, because it's difficult to encapsulate what is environmental. Environment is a very tricky notion. There are notions which are very wide, and if you put examples of air pollution, water pollution, these may be clear cases, but what about historic patrimony? What about landscape? So it's very difficult to encapsulate the notion, but probably the speakers know more than me. Please, do you want to react?
Well, thank you very much, Guillermo, for your question and for reflect on this. I mean, it's a tricky question, as Professor Moreno was saying, no, but I think we are in a part of history, particularly after the Second World War, when we are all trying to build this constitutional international law. And I was referring before to human dignity, no, and that human dignity can be above the traditional sovereignty principle based on Westphalia of states. And therefore, you were referring also to the International Criminal Court. There are, even the European Union is a regional construction based on law and architecture of law that tries to be above the states in particular areas, including human dignity. So I think we are in a part of history that it is very difficult, but I think we have to be optimistic, and at the end of the day, small steps can start a path to very interesting goals. Maybe not in the near future, but for future decades. So the International Criminal Court is one example. There are other initiatives. There are some initiatives focused on the environmental international courts, and I hope that in the future we are able to bring to justice to those peoples that really have committed terrible damage to the environmental, and that sometimes they are way beyond an state. No? So somehow they can affect to a wide variety of states, and therefore there is when maybe an environmental international court can have an important role. Maybe it should be even something like the International Criminal Court or the Inter-American Court of Justice of the European, the Human Rights Court in Strasbourg. I'm not sure if it should be one particularly environmental court or if some of the already built international court could have some competence over those sort of cases. But let's see how in the future decades the future comes out. I hope that in the way you are more or less referring.
Thank you. Dr. Cuvas, do you want to say something?
Thank you very much. You made me think right now. So this is what I could say. And actually, maybe this could also resonate with what you just said about the concept of differentiated duties or obligations. So, well, the word role is a very broad concept, and sometimes roles are not just properties of just one person, individual, or entity, but they can also be relations, and not just relations that register particular power differentials. For example, employer versus employee, right? These are roles, right? Social roles, and they always go together in a pair. By analogy, we could also say that in the case of industrialized and developed nations, there is such kind of a pair of roles, each one having its own duties and duties and rights or powers, if you like. And the way to distinguish the duties of the two sides has to do precisely with this idea of respecting and reflecting the power differential between the two cases. So I would very much welcome such an approach, a role approach, as long as we understand it also in these relational terms that register the power differential between the two sides. Something like the employer versus employee relationship. Thank you so much.
Well, just to add a final word on this, we already have international environmental courts, so to say. The International Court of Justice has rendered many different rulings in the last decades. Capchigo, Naguimaros, the pulp mills of Uruguay versus Argentina. So there are already a body of case law. And in Europe, we have different courts. The European Court of Justice has hundreds of cases related to the interpretation and application of European Union law. The European Court of Human Rights, based in Strasbourg, has a very long case law relating to the interpretation of Article 2, Articles 8 of the European Convention on Human Rights with an ecological dimension. We have also the Compliance Committee within the Aarhus Convention structure, where even individuals can bring complaints against a state for not fulfilling the Aarhus Convention commitment. So we have already something. Maybe not the court you would like to have, but there are already international courts working on this. Thank you, Guillermo. More questions? No? Maybe I can. Okay, you want to ask a question? An easy one, please.
this concept of human dignity, not that easy one, is very appealing to me, and I think it's very proper to use it in this context, no? Especially now that, for instance, the right to water, we are looking at it and seeing that it is not being respected in many ways across the world, so it's directly going...
I think that the people is not listening to you. Maybe you should push a button or speaking loudly.
The bottom is
I think it's
now?
Yes.
I think it's the place.
Here now? Yes?
So I was referring to human dignity as a concept. I see Patricia online, that for sure she would like to address that issue as well, in line with the rights of defenders, because we are seeing that, for instance, the right to water is not being granted to people, and so that's really critical. But that makes me think also the other way around. What about the dignity of non-humans, and whether you have considered, because at the end of the day, we can see that there is a kind of relationship between both. I mean, water in itself needs to be protected, because in the end, it will affect the human dignity of individuals. In this regard, we are facing this movement towards the creating rights, legal rights for the nature. And I would like to learn about your thoughts about this movement, and whether you are considering also to expanding this concept of human dignity towards covering also non-humans within the environmental rule of law. And for Patricia, I would like to ask her, it was very interesting, her presentation. Actually, it's critical for the topic that is part of the Pax Natura want, and I would like to hear her thoughts about strengthening legal standing and covering also civil society. We know that many countries have expanded the concept, but many others have not. One case is Spain, where it is not fully expanded the legal standing for individuals and NGOs against businesses, although against states is possible. But I would like to hear her thoughts about how the situation is, especially in Africa, how the situation is expanding in Africa, and whether expanding the environmental rule of law would help also curtailing the many threats towards defenders of nature. And for our conceptualists, because it's very appealing to me. I mean, I come from the field of the law of the sea and maritime law. So you know there the state of danger is constantly, not just risk, but the state of danger is a concept that is being looking at regularly. And it's very appealing to me, this connection between a state of danger and the principle of precaution. So you can expand a bit more on that. Thank you so much.
Okay, thank you very much, Professor. You raised a very important and far-reaching question. Maybe could have a second table, but I think that we should give the floor first to Patricia. Please, could you reply, or do you have any reaction to the statement of Professor?
Thank you very much. On rights of non-humans, this is an issue that is increasingly gaining traction, as you have rights for rivers, for instance, being asserted. And at the law division, even though member states have not agreed on rights of nature, under what we call the Frontiers in Environmental Law Unit, under the Montevideo Program on Implementation and Progressive Development of Environmental Law, we are already having discussions on rights of nature. And this is an issue that is really not just conjectural, because under the Kunming-Montreal Global Biodiversity Framework, there is reference actually to rights of nature. So we are likely to see this issue becoming more and more imperative. The professor also asked about strengthening legal standing and for examples from Africa. And I'd just like to speak about what has happened in a country like Kenya, where Wangari Maathai's fight for the environment, the very first brush with the law was a case where she sought to take the government to court for building a big story building in a public park. And she was actually thrown out as having no standing. And now fast forward to now, where the Constitution actually opens standing for individuals and also for even when they are not personally affected, and where the country has actually also established a very vibrant environment court, which is actually hearing environmental disputes, and we see a relaxation of standing from a very stringent no standing to now standing for different actors. And maybe to comment on the creation of an international environmental court, this is an issue that goes and comes. Different people talk about the importance of an international environmental court, but there has been no agreement that such a court should be established. And I am sympathetic with the view that we do have international fora that can actually deal with environmental issues. The International Court of Justice, the International Tribunal on the Law of the Sea, not too long ago was called upon to pronounce on the issue of climate change. And if you look at regional courts, and I think regional courts in Europe have been referenced and in the Latin American and Caribbean area, but even in Africa, the African Court of Justice, the African Court of Justice on Human Rights has really made a number of decisions on the environment, as has the African Commission. So there are actually fora in which this can be addressed. And it's likely if ecocide is accepted, then that would go under the International Criminal Court. So in essence, whilst there is no international court on the environment, there is no vacuum. And even under the World Trade Organization dispute settlement mechanisms, we see a lot of issues being spoken about there relating to environmental measures. And that brings some level of discussion of issues that would not otherwise be discussed. Thank you.
Thank you very much, Patricia. We are already running out of time, but since there is a coffee break, I think that we can take a couple of minutes to give the floors to Diego or to Trian to see whether they want to react to the questions of Professor Carballo.
Well, thank you, Ivan. Your question is really, really interesting, and there's a debate about it. No, I'm going to talk just my personal opinion, okay? I think really my view, personal view, is that human dignity is the inherent dignity of a human being is limited to human beings. That's my view. That doesn't mean that the other species have rights, that nature has rights, and that we have an obligation to protect them. Maybe from in an indirect point of view, we could try to link those two concepts. No, for instance, if you don't protect the environment, maybe a person does not have access to food, for instance, or to water, and therefore that could be, and that's at least in my view, the access to food is totally human dignity value. I mean, without food or without water, your dignity is really being infringed. So that could be an indirect way to try to find a common ground. No? But there's maybe our professor, philosophy professor, can instruct us maybe about this doctrine of, I'm going to try to say in English if it's possible, speciesism, more or less. Speciesism. Thank you very much. Whether I think that basically they are saying that I think they are saying that humans should treat with the same respect to to animals or to environmental than to other humans. No, that basically we are basically the same. At this stage, at least, if you read the international treaties, the Declaration of Human Rights, and all the international treaties, so far I think we are not at that point. I don't know if maybe in 50 years or, but let's see in the future how it goes. But that's more, so far I think it's a philosophy point of view, that more than a legal point of view, at least at this stage.
Thank you very much. Trian, do you want to
Just
say
one
something
sentence with respect to the concept of danger and precaution. I think that the way you can link these two is through the notion of anticipation. So there's a huge body of literature about the concept of anticipation. Long story short, think of the case of, trying to predict the weather. I mean, you can never be certain about whether it's going to rain or not, but you take an umbrella, right, just in case it rains. So the idea is in anticipation, as opposed to prevention, you're actually trying to adjust yourself as if danger is already here, right? So anticipation is a form of action that whose target is not to minimize the possibility that harm will occur. You behave and act as if, for example, you're already wet. It's already raining. So in the case of danger, it's as if danger has already realized in certain respects. So it's anticipation, or the anticipatory attitude or motivation that could inform the notion of precaution in such a case. Thank you very much.
Thank you. Well, we arrived to the end of this first panel devoted to strengthening environmental rule of law. I want to thank the speakers for their presentation, both in presence and online. Thank you also to the audience for your attention and the question raised. And now there is a coffee break, and the organizers are going to tell me where the coffee, in La Balconada. And where is the Balconada? Okay, so please ask Montserrat, she will know. Thank you very much.
Thank you very much, Monse, for the organization of this outstanding conference, and thank you to all the colleagues and the panelists that take part in this Congress. I have a commitment, so I have to do my job strictly. I ask to all the participants in this panel to please use your turn 7-8 minutes top, because we need discussions. Discussions normally contribute to the enlightenment of the content of the panels. Okay, so we begin. I don't know if Otto Sviggers is hearing us or is watching us, because I cannot see. Well, anyway, is there? Good morning, Otto. Your turn is the last one, so please take it into account before you... you are there. Hello, good morning from Madrid. Good morning from Madrid, Otto. Okay, so the first speaker is Diño Montalbán, postdoctoral researcher at the University Carlos III of Madrid. He's going to address a topic, rights of nature, harmony with nature. Please, the floor is yours.
Thank you very much for the presentation. I'm going to go directly to the topic in order to take account of the time. On this occasion, I want to focus on the specific elements that the ecological law should possess to mark a true turning point compared to other forms of environmental protection that has been implemented at the national and international levels for over a century. In other words, I inquire about the characteristics that should differentiate ecological law from other already established alternatives, such as the conservationist laws, the pollution prevention laws, or the climate change laws. The conservationist proposal gained strength mainly in the United States at the end of the 19th century and at the beginning of the 20th century. One name is particularly important in the historiography of ideas that shape conservationism, the naturalist John Muir. Muir established that appreciating nature for its own aesthetic or spiritual value was more important than using it as a resource. This idea quickly spread in the United States. Yellowstone was established in 1872, and many other parts later, nationally and internationally. The origin and evolution of the conservation laws reflect two characteristic features. They seek to protect for their own intrinsic value natural spaces especially important for their aesthetic beauty or biodiversity. And second, they aim to control through the reclassification of these areas as public domains under state control. These activities of individuals or local communities that may affect the species or natural objects living in them. The early conservation laws have a clear utilitarian and anthropocentric inclination. They pursued to safeguard natural spaces considered important for human aesthetic enjoyment, often with a colonial and elitist perspective. Alongside this, the focus of these laws were on direct threats, such as indiscriminated hunting and fishing, neglecting indirect threats, such as pollution or the introduction of invasive species. The second characteristic of this proposal is related to the governance of these natural reserves. This initiative originated from scientific groups, colonial domains, or economic elites. In some cases, this led to the loss of the power that indigenous and native groups have over these territories. In Europe, the first national park, Sarek in Sweden, created in 1909, was founded on Sami indigenous territories, affecting the governance that these people maintain in the area and causing various violations of their rights. Another example is France, a country that established their first national parks in its former colonies, in Algeria in 1921, Madagascar in 1927, and many others. The proliferation of these parks was possible thanks to the easiness with which colonizers could expel the indigenous and native population from their territories. Through these mechanisms, decision-making about what happened in these natural spaces moved away from the directly affected local communities and became an exclusively prerogative of the state in some cases and colonial powers in others. In summary, the second characteristic element of early conservation laws is a top-down governance model. The second stage is the fight against pollution. During the 1960s, various social movements emerged against pesticides, nuclear power plants, toxic waste dumps, large-scale industry, and pollution. As a result, in the late 1960s and early 1970s, new environmental laws were enacted in different Western countries. In this context, environmental justice argued that inequality is intimately related and also caused by degraded environments. In urban areas, environmental movements originated from movements for urban hygiene and public and occupational health. This environmental justice model was translated into the right to a healthy environment. Despite the significant advances that the recognition of the right to a healthy environment have represented for the natural protection, several authors have noted that, at least from an ecological perspective, it has important limitations. Its emphasis is only in the unfair distribution of environmental cost. It does not consider the environmental problem as a problem of our civilizational paradigm, but only has an error in cost-benefit calculation. It aims to internalize ecological costs by pricing environmental services, but cost-benefits analysis tend to be biased against environmental regulation, often minimizing the difficult to value ecological benefits and exaggerating the cost of complying with regulations. This anthropocentric and utilitarian approach is the foundation of environmental law. The third phase of anthropocentric environmental protection begins in 1985 with the discovery of the ozone hole in Antarctica. This new phase is characterized by addressing with a global perspective the effects of pollution and environmental degradation. However, while there is an agreement on the planetary nature of the problem, significant differences have emerged regarding its causes and related responsibilities. Let me explain. Global warming is commonly defined as the increase in Earth's average temperatures due to the concentration in the atmosphere of greenhouse gases generated by human activity. From this definition, two different perspectives on the causes of global warming can be derived. First, that the cause of global warming is the excessive emission of carbon dioxide, or second, that the cause of global warming is the accumulation of that pollution in the atmosphere. Taking a stance on one of these causes can lead to different responses. These discursive variations on the causes of global warming have produced three types of anthropocentric responses. First, those that commodify nature through the emission and purchase of carbon credits. Second, those that seek to replace fossil energy through the development of green technology without transforming consumption and development models. And third, those that seek to transform the planet through technology to artificially control its homeostatic cycles. Each of these alternatives emphasize the deterritorialization of environmental conflicts, causing, in some cases, new forms of violation of the rights of certain human groups. The commodification of nature seeks to limit greenhouse gas emissions by assessing a monetary value to these emissions. Such mechanisms have generated new forms of domination. As some carbon credit sales projects have demonstrated. In Guatemala, for example, forced displacement of 450 people, many of them Quiché and Chuk indigenous people, has been reported as a result of the imposition of the Guatecarbón, a project on their territories. This government plan, developed with the advice of the International Bank, aimed to issue 1.2 million carbon credits by creating natural reserve. The other two anthropocentric proposals to combat climate change are energy transition and geoengineering. Both proposals stem from a techno-optimism that, in most cases, doesn't seek to disrupt the capitalist development model. Energy transition aims to combat carbon dioxide emissions, while geoengineering aims to prevent their accumulation in the atmosphere or artificially reduce their effects. All these techno-optimist initiatives stem from an evident anthropocentrism. They don't seek to alter our behavioral parameters toward nature. On the contrary, they aim to increase our dominance over nature to artificially control its vital cycles. They try to manage uncertainty through the global monetization of nature or the promotion of supposedly non-pollution technologies capable of reversing the effects of climate change. The anthropocentric vocation of domaining nature is expressed here through scientific optimism. Thus, the inevitable ecological uncertainty is intended to be transformed into a language of numerical probabilities. In this process, ecological science constructs an environment to make it legible to empirical eyes and thus controllable. This makes the failure in the managing and controlling natural processes and risks attributed not to a civilizational problem, but to a lack of knowledge or competence. Having clarified the approaches and proposals that have dominated the different phases of environmental law so far, we are in a position to attempt to establish which elements ecological law should contain to fulfill its transformative postulate. These characteristics, rather than new ideas, will be corrections to the limitations and deficiencies found in the exercise of each of the previous stages. In the conservationist era, visions of the intrinsic value of nature were already present. However, this developed from elitist perspective that produced new forms of colonization over people and territories. In response to this, a new ecological law should propose eco-social approaches to natural spaces. It should promote genuinely plural governance spaces that avoid hiding new forms of domination behind environmental discourses. On the other hand, the legal laws against pollution, while including social approaches that accounted for the unfair distribution of environmental costs, overlooked reflection on the intrinsic value of nature. This absence gave way to anthropocentric cost-benefit analysis under which nature was treated as an object with purely utilitarian purposes. In response to this, a truly transformative ecological law should incorporate the idea of a catalog of rights inherent to nature, which protects nature against possible threats to the integrity of its life cycles. Finally, proposals against climate change incorporated the interconnected nature of environmental problems, but until now, their hegemonic proposals have developed forms of governance that promote the deterritorialization of environmental conflicts, the false management of environmental uncertainty, and transitions that maintain capitalist dominion schemes over peoples and nature. In contrast, ecological law should, embracing the idea of planetary interconnection, propose the construction of participatory and polycentric transition projects that favor the construction of new narratives about our place on the planet. Models of environmental justice based on the principle of proportionality and plurality in participation, the idea of rights of nature, and proposals for fair eco-social transitions constitute, in my consideration, forms of a true ecological law. The risk of the rights of nature becoming a new name for classic elitist conservationist policies or participatory environmental approaches, leaving aside the inherent value of nature in their discussion, in my consideration, highlight the importance of seeing this proposal as complementary. Granting rights to nature requires that another, a human being, a human collective, or a human entity, exercise representation in courts. The question of who should represent nature in these scenarios allows, at least, discussing the exclusivity that has been attributed to the state to decide about the environment through administrative environmental law or environmental criminal law. Granting rights to nature not only implies rethinking the traditional anthropocentric foundation given to the law, but also, and above all, in which the spaces in which environmental decisions should be made. Thank you very much.
Thank you for your brightful and passionate contribution.
Thank you.
You really trust on what you talk about.
Yes.
So, Professor Ayi, the floor is yours. Professor Juan Cruz Ayi, full professor of administrative law at the UNED, University of Spain, and you are going to address the subject implementing by the diversity targets for 2030, legal steps in the European Union's framework.
Thank you, Carlos. and good morning, everybody. Well, I guess that trying to summarize all the European Union environmental agenda and its policies in general must be like to make a cat's parade on a street. Almost impossible to do. Let's try to do something. It is also quite boring. Speaking about the policies of the European Union can be very thick question, very difficult to understand in a proper way. So I will do a kind of an evaluative assessment more than an evolutive presentation of what had happened in so many years. And this is going to be in three scenarios. The first one is to speak a little bit about the origins of the European Union environmental agenda. Then it will go to the biodiversity idea of the European Union, and finally the new steps, or an evaluative perspective of the new steps of European Union doing facing this issue. Well, we can agree that European Union has fostered the environmental protection regulation in all the countries of the European member states for the last 40 years. It has been really important in the case of Spain and some others. Maybe others had a more efficient approach to environmental before European Union was getting into it. But European Union has doing that in a very particular way. We can think in two ways to enforce principles and laws on environmental of some other issues, like the classical legal system, national legal system, or the international system of law. But European Union has been working in another perspective and another way, coming from its origins and way of doing things. It is coming from a crucial idea, is that we must think that European Union environmental competence is not an exclusive competence. It's not a strong, a clear competence, but it has come in through a step-by-step from an indirect approach, very different to the common agricultural, to the common fisheries, even to the monetary policies and many others. So this has not been the way of European Union getting into environmental. It has come about through another particular way that has been working based on three main elements. The first has been that being an international actor as itself on the international sphere, European Union has negotiated and adopted many environmental treaties, and enforcing this disposition of these environmental treaties, international treaties, to be adopted by European Union countries members in its own jurisdictions, even more than if the countries were doing to do that by itself. Second, European Union create a common bunch of regulation to be implemented in areas like biodiversity, agricultural, ecology, forest, water, contamination, phytosanitaries, so on, so on. Many other indirect approaches on different matters that were coming into force in the countries members of the European Union. And then, in the third place, establishing and reinforcing a lot of instruments, let's say technical instruments that coming into the legal sphere, like environmental impact assessment, strategic environmental assessment, many of them coming from other international treaties or other jurisdictions, that some of them coming from the United States or so on. The integrated pollution and prevention control, the access to the information and justice remedies coming from the Aarhus Convention and implemented by the European Union, all the new ways to face and to cope with responsibility and reparation when an environmental damage has been done. But above all, and I was saying three steps, and this is the fourth, so I say at least three, this is going to be the fourth, is European Union have created a common and transversal group of good and deep interpretative principles as environmental protection framework for the whole European Union and to permeate in the European Union countries. Many of them were coming from the international treaties. Some of them has been adopted in a particular way by the European Union. We were speaking in the previous session about some of them, like precaution or prevention and so on. And this has been a real achievement in the European Union because many of these principles has been the way that the European Court of Justice has been able to enforce the environmental competence soft, not so soft, but let's say soft competence of European Union in the European countries. So this has been the real change. So the second step is to speak a little bit about biodiversity protection, which has been one of the first areas in which European Union adopted a strong commitment. When I'm speaking about biodiversity, I'm speaking about everything what is into the biodiversity abstract concept, like genes, species, habitats, and all the processes and functions that they have between them. And all the services this biodiversity gives to the human being and to the civilization and to the common and the rest of the policies and the rest of competencies. No? So this biodiversity protection of European Union led to the creation of a net of representative habitats on the EU territories to be protected in their species and their geographic areas. No? First of all came after the signature of the Bird and Ramsar Convention, it led to the Birds Areas Directive of 1979. Then came, as you know, the Ecosystem and Habitat Net of 1992, and then both of them and many other improvements were integrated in 2009. But these 20 years has been a kind of impasse, a very slow, even reluctant application of these regulations by the European Union members, also a kind of a struggle between the habitats protection and the biodiversity which is in the background against the economical development of many countries with a clear triumph of the economical development. So now we are in a kind of a dangerous situation in terms of biodiversity protection in the European Union. In this case, European Union institutions has been babbling out about it, taking political and intentional steps, assessments and evaluation, but with almost no effects on the last, let's say, 20 years as a big enforcement system of law on this particular area. So it gets us to the last step, which is what are we facing now in terms of the steps of the European Union? Well, there are like 3 big steps. Many of them can be seen on more detail, but it's not the case for this presentation. The first one can be the biodiversity strategy beyond 2020, in which we are now. Then all what we can put into the European Green Deal. So it's a big bag with that means climate change measures, agriculture farm to table, life program, water, seas and forest directives of the last years. And finally, and this is the moment in which we are, is the law on ecological restoration that is just being proposed by the Parliament, and it's going to be really transformative. This is going to be, in my guess, the watershed of the new targets of the European Union in the biodiversity protection. So, for one hand, this directive, this regulation, is a norm that admits that classical protection, so we say protection, and we can say even precaution and prevention is not working, is not enough, and it's fast efficient. For the other hand, it accepts that biodiversity as an idea is not an isolated competence, it's not an isolated thing. It's something that is going to be a paradigm shift in everything, in almost everything. So if, as it is said in this norm, the 100% of our territory, the broken European territory in terms of ecological life, have to be restored, have to be recovered for 2015. That means that there is a real change coming up. No? These real change need, in my opinion, three elements. The first one is a big impulse to know scientifically all of the insights of our biodiversity, the biodiversity of European Union countries and the whole world, but we are focusing on that. The second is a complete transformation of what we as Europeans really, how we really live, how we move, how we consume, how we food, how we eat, how we consume the water particularly, how we use the seas, how we use the land, how we use the agriculture and everything. And finally, the third is that the ecological restoration needs a competence, a complete ecosystem integration. So somehow this reglement of the European Union bets for a kind of reconciling ecology, thinking maybe in other more respectful times, not this moment. So any new a step of the European Union and European Union members might be done and should be done in this pressing reality that is, in my case, going to be really transforming of many of the other competencies of the European Union, and it's called to be so. So thank you.
Thank you very much, Professor Ayi. We realize that you are a professor of administrative law because you have used your time punctually. And thank you very much for summing up all the regulations and directives, even the case law of the European Court of Justice on the environmental law subject, because it is really a very thought subject to go through. Thank you very much. We wait for you in the discussion. And now is the turn of Liselot Vienne, senior lecturer at the University Carlos III of Madrid and principal investigator of the European Research Council research project, RIVA. You are going to address the subject indigenous visions on nature law, Mother Earth and interdependency. So thank you very much. The floor is yours.
Thank you, Professor. First of all, I would like to thank my colleague Monse for this really kind invitation to be here and to be part of the Pax Natura project, and for bridging this gap, let's say, in Carlos III between the law department, which is at one side of Getafe, and then we from the social science department. So I am a legal anthropologist, but my PhD is in law, so no worries. And yeah, I was invited to talk a bit about the project that we are working on since 2019, though the time limits of 8-9 minutes does not allow me to really explore and explain what is indigenous visions on nature and law, Mother Earth and interdependency. So what I've planned is to share a few of our outputs as we have been working since 2019. We are a very empirical project which has been affected by COVID. So we work in Colombia, Guatemala, Nepal, and also at the UN level, at 3 levels. And one of the outputs that I would like to share with you, which is, I think, a very interesting conversation with the Pax Natura project, is what we just, a few months ago have published after 2 years of hard work with 2 colleagues, Peter Doran from Queen's University Belfast and Jonathan Lillyblatt, who is an indigenous scholar based in Australia, and that is actually a special section in the International Journal of Transitional Justice, which is called Transitional Justice and Nature, A Curious Silence. It's open access. And one of the many questions that we try to address in that special section is actually what we are also talking about here, is why nature, ecosystem, territory has been silent in all the academic and policy debates when it comes to post-conflict processes. How the more than human should be treated in post-conflict debates from the legal perspective, also policy perspective. And what forms of justice, reparation, and guarantees might be appropriate for an ecocentric or an ecological approach to transitional justice. So I really invite you to look at our special issue. We, as editors, wrote an introduction. We have been able to gather 6 brilliant articles from different parts of the world, addressing many of the questions that we invite you to think about at this moment. And we, as the editors, are inviting the human rights and transitional justice community to recognize that many of the paradigms are in transition today. And we heard already this morning, also here, there are many debates about, as one of our colleagues said, the environment is a tricky notion, nature is a tricky notion, ecosystem is a tricky notion. So how do we think about that? How do we look at that? And we really invite the legal community to think about how can we unsettle the dominant modernist dichotomies between nature, culture, human and non-human. When it also comes to post-conflict processes, we really insist that thinking about transitional justice and thinking about nature, ecosystems, etc., that we need to reframe what is conflict and what is struggles, as predominantly it has been framed within a Western liberal imagination, but we need to think about the impact and the histories of capitalism, colonialism, racism, etc. So on the website of the International Journal of Transitional Justice, there is access to the 6 other articles. We as a project, we have been also working in Colombia together with indigenous judge Belkis Izquierdo. You might have heard of the groundbreaking ruling of 2019, where she recognized a territory as a victim of the armed conflict that has sparked a huge international debate, not only in Colombia. I have had the privilege to know Belkis since 2017, so we have been closely collaborating over all those years. If you are interested, we have done several seminars, mainly in Spanish so far, discussing nature, territory as a victim, but also what does that imply for reparation, memory, reconciliation, etc. And as an ERC project, we like to support the change of paradigms also in science. So we started a project last year ago to produce documentaries as a way of communicating our research results beyond the typical academic community. And one of the documentaries, we do it in Colombia, Nepal, and Guatemala, is following actually the judge, Belkis Izquierdo, and I would like to share, if everything goes well, a teaser of a longer trailer of 4 minutes, but just to give her a direct voice.
Grabando. ¿Listo?
Uy, that's not.
Acreditar el...
You know how to do it? So, while Digno or someone of the... Okay. ¿Cuál? ¿Duplicado? Sí. Okay, so I will start over again. I hope you forgive me those.
Grabando. ¿Listo? Acreditar el territorio como víctima es reiterar que es un sujeto de derecho y que es necesario que tenga una voz en el proceso judicial porque son crímenes que afectan la conciencia de la humanidad. Lo que estamos cuidando es para toda la humanidad, es para la vida de toda la humanidad. Este es un trabajo que se tiene que hacer desde la educación, desde la historia, desde el derecho, desde las distintas disciplinas. Llego a Bucintana para reunirme con el mamo Mijavin, reunirme con mamos y acumamas que me permitan desde allí sentir que entro a un territorio sagrado. Hay un mundo físico, pero también espiritual, de espíritus tutelares del agua, de espíritus tutelares del fuego, de espíritus tutelares de la montaña. Creo profundamente en la energía, convencida que las mujeres tenemos la fuerza y la conexión con el territorio. Ese es Belkis.
Encantada.
No sé qué me faltó.
So this is a 1 minute trailer of a 4 minute trailer, and we hope to have ready the full documentary by next summer. We have been collaborating with a local indigenous filming crew, organizing everything from Madrid. So we hope that with this documentary we can also reach legal practitioners to have that dialogue between Euro-Western trained legal practitioners who debate nature, peace, environment, and with indigenous legal practitioners, such as an indigenous judge in Colombia. I also like to share, as tomorrow we're going to talk about strategic litigation. In the project, we have been also working not only with indigenous Judge Belkis Izquierdo from Colombia, but also with indigenous lawyers in Guatemala and in Nepal. And I'm very proud to share that we just published a few weeks ago an article in the International Journal of Human Rights, which is based on our empirical work with indigenous lawyers in Guatemala who have been struggling and doing decades of legal strategic litigation regarding the defense of indigenous territories. And we really invite legal practitioners to learn from our indigenous colleagues about how they, from their indigenous being, are trying to break up that Euro-Western, colonial, racialized conceptualization of law in many ways. And besides the documentary, we also do podcasting, and we have here an academic podcaster next to us. Digno is not only a brilliant legal scholar, but he was also the coordinator of our podcasting. As we see podcasting as an act of insurgency within the academia and to break up that really traditional way of producing knowledge, which is limited to academic articles that we need to do because we are an ERC, but we also love to do other things. So we have an episode about indigenous lawyers from Guatemala and Nepal, that we can learn how they have been doing their strategic litigation in the defense of what we call, from a Euro-Western point of view, nature and ecosystem. And to end, we also work at the UN level to understand how indigenous experts engage with the international human rights system already decades, and how they are trying to break open that, also once again, that Euro-Western international human rights standards norm setting system. And we just published a brief article, a blog, in Green Diplomacy, and together with Digno and with another colleague, an indigenous scholar from my team, to highlight the role of indigenous diplomats within the UN human rights system and how they have been advocating for the concept of Mother Earth, not the concept of rights of nature, by the way. That's actually one of the critiques that we are explaining in this brief article. And we are currently working on a larger article to highlight how indigenous diplomats from different parts of the world have been trying to put the notions of Mother Earth, which are very different way of thinking relating to nature than ours, trying to insert that in international human rights norm setting and the challenges that have been experiencing them. And we have also another episode with different indigenous diplomats in our podcast from different parts of the world. Our episodes are in English and in Spanish, and I think they are a really interesting way to learn from our indigenous legal scholars and practitioners about nature, environment, ecosystem, and how they have a different way of thinking without romanticizing them. They are the first one to say, hey, we know that our indigenous knowledge is getting traction in international arenas when it comes to climate change, when it comes to rights to nature, etc., but please don't romanticize us. But that's mainly an invitation to look into our work. And I'm really looking forward to collaborate with Pax Natura and to find that interchange and cross-fertilization between what we are doing as a project and what is Pax Natura trying to establish together with legal practitioners and legal scholars. Thank you.
Thank you very much. Please allow. To open the door to this magical world, you wish to transform in legal world, isn't it?
Yeah, that's the attempt.
Thank you. And now the floor is for Otto Sfijas. We cannot see Otto.
No, you cannot see me?
Yes. But we can hear you.
Okay.
We can hear you, but we cannot see you. Otto is assistant professor at the University Rotterdam School of Law in the Netherlands. So, Otto, thank you very much. The floor is yours.
Hello? Can you see my slides, my PowerPoint slides?
Yes, yes, we can.
Ah, great. Okay, so I will begin. Yes, well, thanks very much for the invitation. It's a great pleasure to speak to you again. So my topic is the BBNJ. So in June of this year, 2023, the world ended decade-long negotiations leading to a new agreement under the United Nations Convention on the Law of the Sea on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. I will refer to this as BBNJ. So at the ICEL Symposium of 19 November 2021, so 2 years ago, I gave a presentation on global solidarity with nature and the sustainable use of BBNJ. I remember this very well because at the time I was in a hotel room in Hainan in China, because then I was still a professor at Wuhan University. And now I'm speaking to you from a much less romantic site, that is my hometown, The Hague in the Netherlands. So the current presentation looks at where we stand now, 2 years later. I first give an overview of the drafting process of the new agreement, the BBNJ agreement. And then I wanted to look at the differences between the draft that was the topic of my discussion 2 years ago and the final version of the text of the treaty. So I can give a very brief overview of the BBNJ process. In 2005, an informal working group was established by the UN General Assembly, United Nations General Assembly, to study issues relating to the conservation and sustainable use of BBNJ. And this working group met 4 times in the period 2006-2011, and it reached a key agreement in 2011 that there was a need for a new treaty dealing with 4 issues in particular. 1, marine genetic resources, including questions on sharing of benefits from these resources. Area-based management tools, most important of them is marine protected areas. Third is environmental impact assessments, and the 4th one is the transfer of marine technology. And then in 2015, the UN General Assembly established a preparatory committee which met 4 times. And then it gets interesting. In 2017, the same assembly convened an intergovernmental conference, so a conference where states are represented at the state level. 3 sessions were held in 2018, 19, and another one in 2019. And at this last meeting, delegates delved for the first time into textual negotiations based on a 0 draft containing a full treaty text developed by the President Reina Lee of Singapore, who was before an ambassador in my country, an ambassador to Singapore in my country. And then on 18 November 2019, the same Reina Lee published what she called a revised draft, and that one was to be discussed at the 4th meeting. So this 4th meeting was initially scheduled for 2020, but it was postponed due to the COVID pandemic outbreak. So it was only held in 2022, so 2 years later, followed by some additional meetings in 2022 and even as late as 2023, so this year. A further revised draft text was introduced in June of 2022, and then a further refreshed draft text became available in December of 2022. And then on the 19th of June 2023, the treaty text was finally adopted. So I now look at some relevant provisions relating to international cooperation in the revised draft of November 2019, and I want to compare that one with the final version of the treaty, that one that was adopted in June of 2023. So as I already noted in my ICEL intervention in 2021, speaking to you from Hainan, what I found noticeable in the draft of 2019 was that there was not a single mention of global or other types of solidarity in the draft. There were only references to international cooperation. And at the time, I explained why I thought that was regrettable. So just to freshen your memory, this is the relevant text from that draft. Article 2 of the draft states the treaty's general objective, and it is, you can read from the slides, to ensure the long-term conservation and sustainable use of BBNJ through effective implementations of the relevant provisions of the Law of the Sea Convention and further international cooperation and coordination. So to further international cooperation is one of the key objectives of this BBNJ treaty. And then Article 6 of that draft elaborates on the theme of international cooperation, urging states to strengthen and enhance cooperation with and among relevant legal instruments, frameworks, and bodies. And this is a reference to already existing instruments, frameworks, and bodies. But then at the end of Article 6, paragraph 3, you have a very interesting additional provision stating that states parties shall cooperate to establish new global, regional, and sectoral bodies where necessary. So they are urged to establish new bodies to complement what we already have. So then in June of 2023, this treaty was adopted. It has not yet entered into force. Already it has a lot of signatory states, but it has not yet entered into force. So what does the June 2023 version say about international cooperation? Well, we can be very brief about Article 2 because that's basically the same. And then Article 8 has been changed quite drastically, and here you can see what has been changed. So you see that that third paragraph had this suggestion that states parties shall cooperate new bodies has been removed. And that is unfortunate because there are few already existing relevant global, regional, and sectoral bodies. And those that do already exist are not always competent with regards to the conservation and sustainable use of marine biological diversity. So necessitating, therefore, the careful inspection of the competence of each body. We are not sure that already existing bodies can really carry on this task. So it's by no means certain that a cooperation scheme as the one now introduced to us in the new BBNJ agreement can actually function effectively. And then finally, as mentioned above, or in a few minutes ago rather, the treaty text of 2019 did not mention solidarity, not even once. And the June 2023 treaty still has not a single reference to solidarity. So why is that unfortunate? That's because global solidarity and international cooperation are not synonymous. Solidarity encourages the world to pay particular attention to the most vulnerable members within our society. And that aspect is entirely missing in the text. There is some reference to relevant stakeholders other than the community of states. There's plenty of references to civil society, scientific community, private sector, also indigenous people, to relate my intervention to the previous one, and to local communities. So this idea of stakeholders has been enlarged, going beyond the traditional interstate paradigm. But there is no progressive text included in the convention referring to solidarity or any of that kind. I think that is what I want to share with you. So I thank you for your kind attention.
Thank you very much. Well, we have just time for one question. So please go ahead if somebody wishes to. Please, go ahead.
Yeah, thank you so much. One question is for Digno. I was wondering if you had thoughts about the utility of the anthropocentric and ecocentric divide. Well, in my opinion, it would be a little bit sterile if it's not focused on whether by anthropocentric you mean that ecological law protects the subjective.
Please,
say,
shorter.
part of the
We don't
environment.
have many time.
Oh,
Please.
sorry about that. So that's the first question, and the second one is for Liselotte. I was wondering if you had thought about nature as a subject in the special peace jurisdiction in Colombia as having a mere reparation nature instead of an environmental protection finality in the sense of what happened in Tijuana and the Wanganui River that was done to settle land disputes in colonial settings. That was it. Sorry about that.
Yes. Well, in philosophy of law, we divide two types of anthropocentrism, the epistemic anthropocentrism and the moral anthropocentrism. What we discuss here is the moral anthropocentrism. Obviously, always we want to be the one who reflects about nature and their intrinsic value. That is inevitable. I mean, we are the humans here discussing. What we are trying to put into the discussion is that there is no necessary reason why we have to be the only ones that are the recipients of rights, the holders of rights. That can be much more not humans be part of that circle too. No, that's the main proposals, and it's not against the anthropocentric approach. I think that the concentric approach is complementary to the anthropocentric approach. Are not one despite the other. No, I mean, and are together. That's I think the revolutionary proposal about the ecological turn of law. No, that's the only thing that can be revolutionary because other idea has been there for a long time already. No.
Yeah, regarding your question about the Colombian special jurisdiction for peace. So as a research project, we focus more on the indigenous legal resistance with the work of Judge Belkis Izquierdo. However, in the court, I don't know to what extent you are familiar, but there are many macro cases, and the debate about nature as a victim of armed conflict is also heavily debated within the court. I don't know if you master Spanish because there's very interesting legal jurisprudence coming out of the court in Spanish mainly. So I can refer to you. There are other scholars who work more from a legal perspective within the jurisdiction of peace, about nature, ecosystem, etc. So I can refer to you that if you're interested. Okay.
Hello again, everyone. Now, we have the privilege to attend to a very special moment since Maestro Chilla Amos has composed a musical piece specifically for this event. Maestro Chilla Amos is the director and advisor of the Hyrodai Orchestra in Japan. He is live right now in Hiroshima, in Japan. And he's going to be presented by Professor Koken Liang, who is also live from Singapore. And so I'm going to present the presenter. Professor Koken Liang is Emeritus Professor of Environmental Law at the National Singapore University, and also she has been the former director of the ASEAN Pacific Center for Environmental Law, and she's a member of the ICEL Board of Governors. So, good afternoon, good night. Professor Koken-Liang, are you there? Can you hear me? If not, as we know that she's very well organized, she has already pre-recorded a video, audio, to be sure that we are going to be okay. If not, if there is any technical problem, we could listen to your audio. Professor Koken-Liang, are you there? Well, if just in case there is a problem, we could deploy plan B, which is to put the picture of her on the screen and to listen to her audio, to pre-recorded audio.
Good morning.
Oh, yeah.
I'm Koken-Liang, Emeritus Professor, Faculty of Law, National University of Singapore, and member of the ICEL Board of Governors. A very good day to all of you, and welcome to this session on music and the environment. Maestro Amos Chia, ICEL's representative of music and culture for the environment, has composed a piano piece entitled Tempest of Change, Climate Storms. The music is centered on how tempestuous storms brought about by climate change can wreak havoc to ecosystems and humanity's harmony with nature. His composition is a call to urgent action to still the bellowing storms and make peace with nature. Maestro Chia will present the narrative of his powerful music composition as he plays it on the piano. In his words, he has, to quote, meticulously woven together a tapestry of sounds that mirror the ominous dance of hurricanes and typhoons, unquote. A truly inspirational narrative and composition. I now call upon Maestro Chia to make his presentation. Thank you.
And now we will listen to Maestro Chia Amos about his narrative introducing his play, Tempest of Change. Maestro Chia Amos, are you there? Can you hear us from Japan? He's in Hiroshima.
Hi, can you hear me?
Yes, we can.
Hi, can you hear me?
Well.
Is it fine?
Welcome.
Okay, good morning, I guess. Yes, good morning, everybody. My name is Chia. I am Research Fellow in Sustainability Science at Hiroshima University, as well as a teaching fellow here. I'm also permanent conductor and music advisor of the Hirodai Symphony Orchestra and the Hiroshima Tafel Orchestra. And as you know, I'm also a pianist and composer. So today I present a very contemporary piece of music that seeks to convey the urgency of addressing climate change and the devastating impact of climate storms on our environment. Through the medium of very experimental and avant-garde music, I've crafted a rather unique piano composition that embodies the very essence of a climate storm. But before we start on that, I would like to delve into the theme of the conference, towards a legal system in harmony and peace with nature. And I would just like to elaborate how music and culture transcends mere aesthetics and entertainment, and it plays a very vital role in fostering harmony and peace with nature, of course, in the realm of law and governance. So music serves as a very powerful expression of cultural identity. By incorporating elements of diverse musical traditions, we acknowledge the intrinsic connections between culture and the environment. Culturally rooted compositions inspire a very strong sense of responsibility and stewardship towards the natural world, aligning with the goal of legal systems that harmonize with nature. Music also has the unique ability, to tell stories without words, evoking emotions and narratives that resonate on a deep and cultural level. Through carefully crafted compositions, we can communicate environmental laws and narratives, bringing to light the intricate relationship between humanity, culture, and the ecosystems we inhabit. Cultural events, including, let's say, musical performances, also provide platforms to raise awareness about environmental problems by weaving environmental themes into our musical and artistic tapestry, which is what I'm trying to do with many of my colleagues in the art world. We contribute to a broader cultural dialogue that emphasizes the importance of sustainability, conservation, and living. And music also possesses a unifying quality. It brings people together across cultural boundaries, and it has the potential to inspire collective action, and I hope it does. And it fosters a shared commitment to environmental responsibilities within legal frameworks. In conclusion, I present this very experimental composition as a call to action. I would like to let the music inspire you to use your legal acumen to tackle the climate crisis head on, to be the voice of nature that speaks up for a world free from the relentless fury of everything that's going on. Music and culture are not mere entertainment, but I believe, and I hope to believe, that they are integral components of the conversation around environmental law. Through compositions, music, and cultural work inspired by diversity and a deep respect for nature, we as artists, we hope to contribute to a legal system that is not only in harmony with the environment, but also draws strength and wisdom from the rich cultural tapestry. All the sounds you hear today are actually produced on a modified grand piano. They are modified by me, and it's also performed by me. It's a recording, actually. The music starts with a very delicate ringing of wind chimes, and that's actually on the piano. It symbolizes the tranquility of a pristine environment. It's unblemished by the forces of nature. It evokes memories of a carefree summer day when the gentle breeze is maybe brush against our skin as we relish the harmony of nature's symphony. But the piece is short-lived. As the composition transitions into a very turbulent landscape, the wind howls, the storm rages, and it reflects the escalating intensity of climate storm. There's thunder sounds and there's a war drum echoing the alarming rise in extreme weather events that have been amplified by climate change. In this experimental composition, I have woven together a tapestry of sound. I tried very hard to imitate and mirror the dance of hurricanes and typhoon. The music illustrates the sheer power of these natural storms, which demands our attention and immediate action. As the composition reaches its climax, the chaos of the storm resonates through every note. It reminds us of the immense toll, such as climate events on the ecosystem, communities, and human lives. We cannot turn a deaf ear to the increasing frequency and intensity of these storms, nor we can remain complacent in the face of escalating climate crisis. But soon, amidst the chaos, the music gradually subsides. It returns to the peaceful ringing of wind chimes. This symbolizes hope and opportunity that lies within us. It's an invitation to action, urging us to stand united against climate change and to advocate for more transformative policies that can protect our environment. So, Professor Monse, I hope you can begin the recording now. Perhaps if you do have it with you.
Yes, of course, don't worry. I think that everything is ready
yes,
now.
Thank you very much.
Thank you, Maestro Chiamos, for your
yes,
inspiring and powerful
yes.
words. We are eager to listen to your musical piece. So,
yes, all right.
3, 2, 1.
I thank you very much. I hope it wasn't too avant-garde for everyone. And just so you know, it's composed and performed on the piano. It's 100% on the piano. I actually modified it. I tried to do something different. But may this musical journey inspire more fruitful discussions and collaborations towards a legal system that would reflect the interconnectedness of humanity, nature, and culture. And I thank you all, and I wish you all a great day ahead. I can't hear you.
I was saying that thank you. We are very grateful because you have composed this piece specifically for this event, so we are really, really, really grateful. And well, I was adding that I had perceived a certain change of style in comparison with previous compositions, and I realized that this is very well adjusted to the message, the current message that you want to convey in this occasion. And it's a very powerful piece, and well, I see here faces of pleasure. But it is a message for action as well. It is a message for action as well. And well, your role as representative of ICEL for culture and music for the environment is very relevant, and you are fulfilling your role very, very well. We appreciate it.
Thank you very much.
Congratulations.
I try my best. Thank you very much.
Congratulations,
Yes.
and
have a great
you.
day ahead. Have a great lunch ahead. I
Yes,
guess it's lunch
thank
time.
you, and you have a good night.
Have a great lunch. Have some coffee. Yes, thank you very much.
Thank
Yes.
you.
Yep. Have a great day ahead.
Okay.
Ciao.
Well, the next section is the panel 3, expanding legal frameworks and policies around nature, security, conflicts, and peace, which is chaired by Dr. Andrés de Castro. So the members of this panel can come here.
Good morning. My name is Andrés de Castro. I'm the Deputy Director of Instituto Universitario General Gutiérrez Mellado, a joint institution between UNED University and the Spanish Ministry of Defense. I first want to thank Professor Abad and our colleagues and organizers for today's activity. It's a true honor to be here today. The third panel is called Expanding Legal Frameworks and Policies Around Nature, Security, Conflicts, and Peace. The first topic and speaker, I'm very proud to have Professor Escobar here today. She's a full professor at UNED, and she has a very extensive CV that we all are aware of, and she will talk about ILC principles on protection of the environment in relation to armed conflicts. So, Professor Escobar.
Thank you, Andres. Good morning, everybody. And before starting my presentation, let me say how I appreciate the invitation from the organizers, in particular University, Carlos III, ICEL, and Professor Abad Castello for the kind invitation to participate in it and make a short presentation on an issue of great relevance for enhancing the protection of the environment at international level. During the last two quinquennia, the International Law Commission has addressed the issue of the protection of the environment and climate change at international level through different topics and from different approaches. The protection of the atmosphere, first of all, the protection of the environment in relation to armed conflict, and more recently, the effect of sea level rise in international law. Undoubtedly, for the purpose of the present conference, the most relevant work is the draft principles on the protection of the environment in relation to armed conflict, PERAC, adopted by the ILC in August 2022 on the basis of process developed under the leadership of Ambassadors Mary Jacobson and Maya Leto. The draft principles is the answer of the ILC to the 209 requests from UNEP to proceed to a review of the rules of international humanitarian law applicable to the protection of the environment. The ILC work has been developed in parallel to the ICRC's guidelines on the protection of the natural environment in armed conflict adopted on 2020. However, PERAC differs from the ICRC's guidelines, which addresses the issue solely from the perspective of means and methods of combat and the protection of civilians affected by a concrete armed conflict. On the contrary, the ILC principles have been set up on the basis that environment is a subject of protection in itself, which enhancement is the main purpose of PERAC. The ILC principles don't intend to modify the law governing armed conflict, but advance a set of principles based on the fact that environment suffers or may suffer serious harms as a result of the planning and or development of an armed conflict, and that such harms have often far-reaching consequences that are sometimes difficult to repair. The ILC principles have the great value to address the protection of the environment in an all-encompassing normative way, taking into account not only the rules of international humanitarian law applicable in an armed conflict, but also the rules of international human rights law and other relevant sectors of international law, including environmental law, the law of disarmament, or the law of the international responsibility. At any rate, international humanitarian law is understood and continues to be lex specialis when the environmental protection must be considered in the context of a specific armed conflict. The instrument adopted by the ILC is characterized for the following elements. First of all, environment is the axis of PERAC. Second, principles refers both to international and non-international armed conflict. Third, the principle listed in PERAC apply to the protection of the environment before, during, and after an armed conflict, including occupation. Fourth, the principles relate both to the prevention and mitigation of damage that may be caused by the environment in relation with an armed conflict, but also to the obligation to repair any damage and to the recovery of the environment in the aftermath of a conflict. The treatment of environment by PERAC is all-encompassing also from a substantive perspective, including not only the protection of the environment in itself, but also the incidents that such protection will have on human life, health, food and water security, cultural tradition and heritage, and the enjoyment of other human rights, as well as on the protection of natural resources. The fifth characteristic feature is that the duties and recommendations contained in the draft articles are addressed to states, in particular those participating in the armed conflict, but not only to them, to international organizations, to other parties involved in the conflict, the non-state actors, but also to private entities, especially companies that carry out some type of activity that may affect the environment. Only individual criminal responsibility is not expressly included in PERAC. The sixth feature is that PERAC is not a binding instrument in itself, but as usual in the ILC works, it includes both principles codifying rules and principles already in force, lex lata, and principles of progressive development of international law, lex ferenda. The first set of principles refers in particular to rules of ICEL, disarmament and international responsibility of states and international organizations. The second set includes mainly principles about prevention and, in a certain way, reparation of damages. Seventh, in any case, I have to underline that the protection of the environment is submitted to a specific Martens clause. Those of you who are familiar with ICEL can really understand what the Martens clause means. The protection of the environment is submitted to a specific Martens clause, according to which, in cases, and I quote, in cases not covered by international agreement, the environment remains under the protection and authority of the principles of international law derived from established custom, from the principles of humanity, and from the dictates of public conscience. This approach has enabled the International Law Commission to develop a solid instrument for the protection of the environment in relation to armed conflict that addresses a wide range of issues, among which I would like to call your attention on the following. First of all, the primary qualification of the environment as a civilian good, and as a consequence of it, the prohibition of any international military attack against environment, unless it could be considered as a military objective. Second, the prohibition, and in addition to that, the prohibition of reprisals against the environment and the prohibition of pillage of natural resources. The second main content refers to the establishment of a model of protected zones before and after the conflict in order to protect environment, including in these zones those containing properties of special cultural significance. The third group of contents refers to the protection of environment in connection with specific areas, such as the right of indigenous peoples, the migration and other movements of people, the stationing of troops, or the deployment of a peace operation led by an international organization. The fourth group refers to the definition of a general duty of states to take measures, legislative, executive, and others, relevant for the protection of the environment, including legislative measures to ensure the respect of the principle of due diligence by private companies and to ensure the liability of such companies for damages caused to the environment in relation with an armed conflict, in particular during occupation. The draft articles, the draft principles, PERAC include also a set of principles devoted to the strengthening of state responsibility for any damage caused to the environment, more than the existing rules on responsibility. So the system, the PERAC make a clear definition, establish a clear definition of a system for the disposal of remnants of war, including environmental assessment tools. Seventh, this definition of a new model of reparation. And eighth, the PERAC has the great value to include a clear reference to international cooperation as a key element to ensure the highest protection of environment. As you can see, the ILC principle serves to an ambitious purpose. Having said that, what will be the future of PERAC? As I have said before, PERAC is not a binding instrument, but its legal nature and value are undeniable. At the moment, suffices to underline that the United Nations General Assembly has taken note of principles in its Resolution 77/104 of 7 December 2022, including them as an annex to the resolution. The General Assembly has called on states, international organizations, and other stakeholders and interested actors to examine the principles, to take them into account when adopting measures and policies related to the environment, and finally, to disseminate the draft principles as widely as possible. I wish the real impact of PERAC in the enhancement of the protection of the environment could be as relevant as expected by the ILC. Thank you for your attention.
Thank you so much, Professor Escobar, for your presentation. We're going to move to Professor Joaquin Alcaide Fernandez on protected areas. Professor Alcaide is a full professor of public international law at the University of Sevilla. Thank you.
Thank you, Mr. Chairman. Let me just a few seconds to congratulate and thanks to the real architect, but also to the executive architect of this program, Professor Abad and Professor Carballo, and architect also of the research project that is behind this symposium. Thank you very much. And I'm presenting 5 simple ideas about the protected areas. That is the topic that has been assigned to me. I hope that I will do in the time allotted to us. The first idea is that the initiatives aimed at protecting the environment in relation to armed conflicts has been built upon the intersection of humanitarian law and environmental law in the recognition of area or territory-based protection regimes. There are many kinds of those regimes in environmental law: protected areas, wetlands, natural and cultural heritage sites, natural reserves, coastal and marine areas, etc. It's true that so having the potential to furnish protection to the environment, the militarized zones embraces in maritime law has not yet been operationalized to that end. But as Professor Escobar has explained us, the International Law Commission has included in the PERAC principles the so-called protected zones, the principles 4 and 18. This intersection suggests the interrelationships between those regimes, the humanitarian and the environmental area protections, area-based protection regimes. As the International Law Commission indicates, protected areas established according to environmental law could qualify as protected zones, and the obligations contained in multilateral environmental agreements that establish those protected areas apply to protected zones. The second idea is that different types of armed conflicts, actors and activities have different impacts on environment and the practice of protected areas management. The impacts can be related to military activities by direct harm and by collateral damage, such as spillover activities, the environmental footprint of conflicts, and the conservation governance vacuum. An empirical study published very recently highlights that directly or indirectly, protected areas can also be impacted by secondary effects, non-military consequences of armed conflicts, and that is not a coincidence that when not in the areas of environmental importance, armed conflicts and refugee displaced camps are located significantly close to those areas. The third idea concerns the PERAC principles on protected zones. The designation of these zones can be carried out by agreement or otherwise, that is, by reciprocal or unilateral declarations or through an international organization. There is a history of and need for those with protected area management experience to be involved in the negotiation of protected zones, even with non-state actors. Once designated, the protected zone has a civilian character, and the minimum protection against any attack is conditioned to strike a balance between military necessity and humanitarian and environmental concerns, bringing up the application of the principles of distinction, proportionality, and precautions. Otherwise, all parties to the conflict are also required to respect any other additional agreed protections. It is obviously necessary to inform the development and to develop FFT measures for implementing those PERAC principles. The fourth idea is that humanitarian law has so far come up short in delivering environmental protection on the battlefield, and that is worthy to analyze the applicability of environmental law to determine how and to what extent may contribute to the further protection of those protected zones during armed conflicts. This contribution might be remarkable in at least two ways: the interpreting and the complementing of humanitarian law. Indeed, environmental law can offer guidance on the issue of the designation of areas as protected zones, might help greening the demilitarized zone, or inspire the inclusion of a set of preparatory obligations before the armed conflict. On the other hand, while avoiding normative conflicts, the continuity of environmental treaty obligations during the armed conflict, their extraterritorial applicability and their applicability to non-state armed groups might permit environmental law to complement the humanitarian law protections before, during, and after armed conflicts. The potential of environmental law could be valuable to both reinforce and mirror the international law protections, the humanitarian law protections, It has been proven that teaching humanitarian law to wildlife service rangers in South Sudan has positive results on the ground, given that the identification of neutrality and non-belligerency could enable protected area management activities to continue, even in protected zones located in opposition territory. Eventually, the co-applicability would ensure co-applicability of humanitarian law and environmental law would ensure that environmental treaty bodies and third states have a basis upon which to promote conservation work with parties to the conflict. The last idea is about the necessity to bear in mind the dark sides of the area-based protection regimes. It has been pointed, for example, the increase of militarization of the protected areas, the introduction of a model of a securitized or militarized conservation, or the use of an area-based regime to exclude or restrict the rights of the local communities. For example, 3 years ago, it was reported a decision of the government of the State of Israel to open 7 new natural reserves in the West Bank, and more than a third of the proposed location appear to lie on private land owned by Palestinians. That's all. Thank you very much.
Thank you, Professor. Let's move on to the third presentation. We have the honor to have Dr. Hansen with us, who's going to talk about ecocide and crimes against nature. Dr. Hansen is a Maria Zambrano Distinguished Researcher at Universidad Carlos III de Madrid. Dr. Hansen.
Great. Thanks, Andre, for the kind introductions. And thanks to our colleagues, Professor Abad and Professor Caballo, who have taken the lead on organizing this important event. I very much look forward to taking part in it and to hopefully collectively take forward this. Can you hear me? Right, okay. So I was just thanking Professor Abad and Professor Caballo for taking the lead on organizing this important event, and I very much look forward to taking part in it, and I hope we can collectively take forward this agenda of environmental justice. And in my case, I'm particularly interested in accountability for serious environmental crimes, including ecocide. So that's what I will try to focus on in this presentation. So on to my main arguments in that regard. The first is that accountability for serious environmental crimes is needed more than ever. The second argument is that we now see some significant and quite far-reaching developments at the national and the regional level to that effect, as many countries have recently adopted or are on their way to doing it, much more solid environmental crimes legislation. And also we see important developments, of course, at the European Union level with the recent adoption of the Environmental Crimes Directive. Last point to open up is that even if all of that happens, current debates about environmental crimes accountability tend to still focus overwhelmingly on ICC and the ICC's adoption of the independent expert panel proposal of ecocide tabled in 2021. Even if, in my view, it should be clear that there are significant hurdles towards adopting that proposal, and even if that should happen, there would also, in my view, be significant hurdles in terms of actually promoting accountability at ICC level for the type of actors that we would like to see held accountable for ecocide and other serious environmental crimes. So I'm splitting my presentation into 3 main parts, and I'll try to keep it brief. I know we don't have so many minutes for our presentation. So the first part is about ecocide norms adoption at the ICC level. And my key argument on that note is that predominantly directing attention towards pushing for the ICC's adoption of the IEP proposal could be disproportionate, perhaps even misplaced, because of the substantial challenges and risks associated with trying to adopt the proposal at ICC level. And even if that ultimately does happen, the expected difficulties delivering meaningful accountability outcomes for ecocide and other serious environmental crimes at ICC level. So first of all, I think it's important to note that going by public statements, actually there currently is a quite broad and exceptionally quickly growing range of influential actors that support the ICC's adoption of the ecocide proposal, and of course that's encouraging to see, at least from a symbolic perspective. At the same time, some key players in the global order, the UK and the US come to mind, have made it clear that they're disinclined to support the adoption of the proposal as it currently looks. And it seems to me that's a fact that is being overlooked in much of the debate about about ecocide. So to be clear, some key stakeholders in the Western-led global order, which I believe is best understood through the notion of the rules-based international order, will likely prove disinclined to ultimately support the ICC's adoption of the ecocide proposal. Why then do these states oppose the proposal? And looking to the different statements that have been made, it seems clear that some key players prefer an ICC system that effectively continues to focus on the types of crimes that it has effectively prosecuted to date, namely core atrocity crimes in conflict zones in the global south, or actors that operate outside this rules-based international order, such as Russia. So what they fear quite clearly is that by adopting the ecocide proposal, the jurisdiction of the ICC would be expanded in such a way that it could permit more focus on actors aligned with these actors. So that seems to be the key point. And that's perhaps usual or quite common that we have resistance to suggested changes in international legal systems, and what quite often happens when we have these diverging views is, of course, that a compromise solution would need to be reached in the context of a possible amendment process within the Rome Statute system. So my biggest fear probably is, on that note, is if that happens, it could lead to a watered-down adoption of the ecocide proposal, which I fear could lay the ground for state parties to adopt less comprehensive environmental crimes legislation than what is currently the case. So it could have a trickle-down effect in that sense that would be negative from the perspective of environmental justice and environmental protection. So on to ecocide norms enforcement at the ICC level. So assuming that an ecocide proposal will ultimately be adopted, these reflections are how would that then likely play out at the ICC level? And my main argument in that regard is that meaningful ecocide norms enforcement at the ICC level will regrettably also very likely prove difficult. So an important first point here is that the ICC's adoption of the ecocide proposal is seen by many of its supporters as important, not only because it would permit the ICC to increasingly focus on environmental crimes, but also because it's seen to permit focus on a specific category of offenders that are deemed particularly important for the ICC to target, namely powerful elites in the West. And I fully agree. I think it's absolutely vital to address existing accountability gaps for the powerful in operating out of the Western-led global order. I'm just more skeptical that the ICC will really have the ability or would really be geared to be the institution, to be the body that could facilitate that. So I'm afraid that the structural challenges surrounding implicit in the ICC system that we know of already will likely remain in place also for ICC ecocide prosecution. So if I'm right in that assumption, what would that then mean? Would it mean, as proponents of ecocide adoption at ICC level indicate, that the court will be able to prosecute executives and large business enterprises operating out of Western countries involved in massive pollution, or the political leaders who facilitate or permit that? I'm not so sure that's going to be the case. So my point is that even if we do see environmental crimes prosecution at the ICC level, it seems most likely to me that it would follow the pattern that we have so far seen over the last 20 years or so within the ICC system, where it is mainly low-ranking or mid-level perpetrators in conflict zones outside the West that are being prosecuted by the ICC. So if that happens, would ecocide campaigners be even remotely satisfied. I don't think so. I personally would not be very satisfied. So with that, I want to end my presentation on a more positive, on a more encouraging note, to say that what we're currently witnessing is actually quite amazing at the national and at the regional level. A very large number of countries have in recent times adopted much more comprehensive environmental crimes legislation that I think most of us even dare dream about just going back a few years. The European Union Environmental Crimes Directive, again, looks quite promising, I believe, and seems to satisfy the demands of many of those who have pushed for that with much energy over the last many years. So my point is, why don't we try to focus on what seems to be working fairly well, rather than throwing so much energy towards an ICC system that in many ways perhaps are already losing its legitimacy exactly because of this failure to go after the powerful. And of course we only need to look at what is currently going on in Gaza and how the ICC prosecutor has perhaps approached that situation in ways that many would find less than convincing. Obviously, a situation that involves crimes by powerful actors or crimes by actors that are supported by powerful actors. So let me end my presentation on that note by encouraging that we focus our energy on what seems to be working well, rather than what would quite likely not work so well. Thank you very much.
Thank you so much, Dr. Hansen, for your presentation. And last but not least, we have Dr. Álvaro Jarillo's presentation on climate change and NATO's strategic concept of cooperative security. Dr. Álvaro Jarillo is a senior lecturer of public international law at UNED University. Dr. Jarillo.
Thank you very much. Hello to everyone. Well, first of all, allow me again a few seconds just to thank and to congratulate for the partners organizing this seminar, and specifically to Professors Abad and Carballo. It's an honor for me to share this panel with the colleagues that I admire so much and to whom I owe so much in some cases. My contribution will be very brief and very specific, since I only intend to highlight a very specific development of the last NATO concept of cooperative security. I'll try to show you how much this concept has strengthened the relationship between the international security and the fight against climate change. In this sense, I'm afraid I'm going to offer you more questions than answers, but I'll do my best. Well, the starting point is 2010, when NATO's strategic concepts already mentioned some environmental aspects and issues like key environmental and resource constraints. And at that point, they were conceived as a factor that influenced the security environment in which NATO operated. In this original meaning, the concept of cooperative security was defined in these NATO documents as active engagements to enhance international security through partnership with relevant countries and other international organizations. This idea, this original idea, is aligned with reinforces multilateralism included, for instance, into the Spanish National Security Strategy of 2021. At this NATO level, to strengthen these ties in the field of cooperation, those documents mentioned areas such as arms control, non-proliferation, and disarmament, for instance. But it was at the Madrid summit when the relationship with climate change was formally introduced and reinforced. In this new strategic concept approved at the Madrid summit, the real qualitative change took place in the consideration of the environmental issues. For instance, we can underline that the concept of climate change itself appears 10 times through the document. I will highlight only two of the most important topics that I think that were included. I'm trying not to bore. In paragraph 19, which is the last paragraph of the strategic environment section, always related to security, it says that climate change constitutes a multiplier of crises and threats. It can exacerbate conflicts, fragility, and geopolitical competition. Therefore, this is the common idea that we know all, that confirms the perception of the climate change as a factor that accelerates conflicts. But in paragraph 46, which closed the section dealing with this conception of cooperative security, it says that NATO should become the main international organization when it comes to understanding and adapting to the impact of climate change on security. This sentence is aligned again with the nature and purposes of the organization, but the same paragraph goes even further when it says that the alliance will lead efforts to assess the consequences of climate change for defense and security and address those challenges. In this nexus between the effects of climate change and security, some articles and some documents have begun to mention the terms climatization, as we did in the past with other terms like securitization. The problem with these new documents is that this excessive use, as we are doing in the case of resilience, for instance, can generate some confusion around its appropriate delimitation and scope. In general terms, thanks to these commitments, apart from this confusion surrounding always the concept, in the last months, at the NATO level, there have been some initiatives such as the NATO Climate Change and Security Action Plan or the Climate Change and Security Impact Assessment, which has been developed within the Alliance. These initiatives usually refer to some of the key concepts that we have been dealing with in this seminar in the field of the effects of climate change, such as awareness, adaptation, and mitigation. This progress of the Alliance towards climate change effects has occurred while at the level of the UN Security Council has failed to recognize a general relationship between climate change and security. The most relevant attempt to pass a kind of omnibus resolution took place in September 2021, but the Russian delegation refused to consider the effects of climate change as a global threat to peace that should be formally incorporated into the Council agenda. Given this situation, in this first step taking place since the Madrid summit, the questions, I have selected only 2 questions, to be answered in the present and the near future are: has this change in the alliance occur only from a formal point of view, or will it be transformed into concrete action based on the action plan? I mean, will it remain a mere pathway that can guide the action of the states, or will it give priority attention to the effects of climate change in the analysis of threats and risks to the transatlantic security? The second question could be, how much strategic and how much political is this commitment of the member states of the alliance? From an institutional point of view, to what extent will this commitment to climate change help to open new areas of cooperation for the alliance with other institutions and organizations such as the EU, the Intergovernmental Panel of Climate Change, or the United Nations Environmental Programme, for instance? In summary, my central question to be answered is whether the concept of cooperative security in its relationship with climate change will be an opportunity or a vacuity. I thank you very much for your attention. That's all.
Thank you so much, Dr. Jarillo, for your presentation. We'll open a very, very brief space for Q&A. If somebody has any questions or comments to make. That means that everything was very clear and that they left no room for any thing that wants to be expanded. So thank you very much for your presence today, and a true honor to be accompanied by you this morning. So thank you very much.
Good afternoon. Good afternoon and welcome to this crowded session. My name is Carmen Pérez. I am Professor of Public International Law here at Universidad Carlos III and also Vice Dean for International Relations at the Law and Social Sciences faculty. First of all, I would like to thank Professors Abad Castelos and Laura Carballo for inviting me, having me today with you, chairing this panel titled Addressing Environmental Refugees' Needs, Main Legal Challenges and Opportunities Ahead. We have 6 speakers. I will present them, and then they will take the floor, and they know they have around 7 minutes, 8 minutes. Yeah, I know it's short. And to help them, I have this, and I will show you this to them, try to help to control time. First, we will have Professor Susana Borràs Pentinant. She is an Associate Professor of Public International Law and International Relations and also coordinator of the PhD program in Law Research Group Territory, Citizenship and Sustainability. And she's a member of the CEDAT Institute for Research in Sustainability, Climate Change and Energy Transition, EU-RESCAT at Rovira y Virgili University in Tarragona, Spain. The title of her presentation is Climate Change and Non-Refoulement. Then we will have Dr. Justo Corti Varela, who is also an Associate Professor of Public International Law at UNED, Universidad Nacional de Educación a Distancia, and also Principal Investigator of the German Action on European Climate Change Law in Spain. After Professor Corti Varela, Mr. Gonzalo Sánchez Terán will take the floor. He is Deputy Director of Humanitarian Programs of the Center for Humanitarian Cooperation at Fordham University in New York. I didn't say the title of the presentation of Professor Corti Varela. It will be Environmental Degradation and Displacement in Latin America toward a new customary rule, and the presentation of from Gonzalo Sánchez Terán will be Climate Refugees and Humanitarian Action. The 4th speaker will be Professor Gloria Fernández Arribas. She's, again, Associate Professor of Public International Law at Universidad Pablo de Olavide in Seville, Spain, and she's also the Principal Investigator of the project Climate Change and Displacement in the Sahel, funded by the Junta de Andalucía in Spain, and the title of her presentation will be The EU Response in the Displacement to the Displacement from Sahel. Then we will have Professor Ruth Abril Stoffels, who is Associate Professor of Public International Law and Director of the Equality Unit at Universidad CEU Cardenal Herrera in Valencia, Spain, and she will be presenting on women and girls in international and internal displacement caused by environmental degradation, some challenges and responses at the UN level. And last but not least, we will have Mr. Javier Jaramillo. He is trustee of the World Law Foundation, lawyer and manager at PropCorp. And the title of his presentation will be Artificial Intelligence and Refugee Law, Exploring the Benefits and Risks of Artificial Intelligence in the Face of Climate Change and Environmental Damage. So thank you very much on behalf of the organizers to all our speakers today. And since we are short of time, from now I will give the floor to Professor Borràs Pentinant. Susana?
Thank you very much. Before to start, I would like to thanks to Professor Abad and Professor Carballo for having me here. And also, I am really delighted to share this panel with a lot of friends. Just making some reflections on climate migration. So my commitment is to refer to non-refoulement principle as a pathway to protect climate migration. protection, since to date, no international regime includes climate change and environmental degradation as a ground for protection. Therefore, international law is failing to protect climate migrants, although that UN High Commissioner for Refugees states that climate change shocks are linked to the displacement for about 20 million people annually. While climate change is not included as a reason for well-funded fear of persecution under Geneva Convention, climate migrants could potentially benefit from the principle of non-refoulement if they are subjected to inhuman or degrading treatment in their country of origin upon return. There is a legal hope, by the way, resulted after the landmark decision adopted in 2020 by the Human Rights Committee on the case of Teiti Iota. The Human Rights Committee regarding to the UN Covenant on Civil and Political Rights. Teiti Iota, a citizen from Kiribati, applied for asylum in New Zealand on the basis that climate change impact exposed himself and his family to violent land disputes, lack of clean fresh water, inability to sustain a livelihood due to soil salinization and flooding. The New Zealand authorities and courts rejected his application according to Refugee Convention, and he and his family were removed back to Kiribati in September 2015. He filed a complaint at the Human Rights Committee, arguing that by deporting him, New Zealand violated his right to life, exposing him to a real risk of irreparable harm. The Human Rights Committee applied a test based in two criteria to determine if this right to life was violated or not. First of all, the existence of an exceptional circumstances. It means that to be faced an extreme and exceptional circumstances that put fear to be violated the right to life. This criteria was, according to the Human Rights Committee, based on the fact that it's not necessary to demonstrate a personal risk. It is necessary to demonstrate there is exceptional circumstances under which the right to life can be violated. However, in this case of Kiribati, regarding to Teiti Iota and his family, the Human Rights Committee did not apply such criteria, even though knowing that the climate change harm is indiscriminate and Kiribati is facing an extreme situation due to the sea level rise. And the second criteria is the imminence of potential harms. It means a real risk of irreparable harm which is imminent, that puts in danger the life to Teiti Iota. Once again, in this case, also fail the Human Rights Committee in the sense that Kiribati will not be any more habitable since, according to the scientific community, will probably disappear in the next 10-15 years. So the adaptations measures adopted by the Kiribati government are scheduled behind. By the way, in this case, the Human Rights Committee decided that Teiti Iota removal was lawful, mainly because Mr. Teiti Iota failed to provide evidence of this imminent death or serious harm for him or for his family. He didn't demonstrate enough to the Human Rights Committee that he faced a real risk of being harmed in any land disputes. He was not able to demonstrate that he faced the consequences of growth, food production, or the lack for have access to drinking fresh water, and in addition, he didn't demonstrate that his situation was not materially different from other people or national living in the Kiribati. So therefore, Teiti Iota case represents by the way, an important contribution to the capacity of international human rights to deal with climate change migration, even if the outcome was not favorable for Tetiota and his family. But the most important outcomes from this decision, which is not binding, is that the argumentation is expanding the scope of the right to life, linking to the life in dignity circumstances. The Human Rights Committee states that countries might consider asylum claims resulting from climate change in the next future. And this recognition is quite important, since for the very first time, climate change has been considered as a trigger of non-refoulement obligation under international human rights law. So from this decision, countries have the obligation to not deport individuals who face climate change shocks and induce conditions that could violate their right to life. But the most important thing in this decision, which was objected by several members of the committee, is that the committee failed to guarantee life to Tetiota, since this high burden of proof was not sufficient for Mr. Tetiota to provide evidences. So the dissident opinions of some members said that it's not possible to wait until death or until climate shocks provide death to guarantee the right to life. By the way, it's important to remind that thanks to this decision of the Human Rights Committee, we have now another standard of protection of the right to life linked to climate change shocks, applying the non-refoulement principle in the sense that can permit to domestic courts, as has happened in Italy or in France, to apply this principle outside of the Geneva Convention to protect climate migration for the very first time in international law. Thank you so much.
Thank you very much, Susana, for your presentation and for keeping the time. Now I forgot the order. Yeah. Now we move to Professor Justo Corti.
Thank you
Varela.
very much.
Thank you.
Mr. President, I would like to thank you organizers Thank you very much, Ms. President. I would like to thank you organizers for the invitation to the consortium of the Free University that organized the event, and also to the International Council of Environmental Law. Well, my presentation will try to make a connection between displaced people in the context of environmental degradation. In this short introduction, I would like to say that I would like to include inside the content of my presentation not only environmental degradation itself, but also the context of migration or displacement because of natural disasters. Since in Latin America, which is the geographical area where I focus my attention, both contexts are normally ruled together. I will divide my presentation into three parts. Firstly, I will talk about the particular way that in Latin America it is defined the concept of refugee. Secondly, I will talk about non-binding documents that call for a particular interpretation of what is a displaced person because of environmental degradation and how we shall protect them. And finally, I would like to make some comments about national law that, on my view, are trying to apply this particular definition of refugees and also these non-binding documents, and from my point is the first step for a future custom in regional international law. Well, regarding the first point, as you know, and my colleague Susana has said, in the definition that we use in the Geneva Convention of Refugee. There is no way, there is no space for the context of climate refugees or environmental refugees. However, there are two regional documents that enlarge this definition. The first one is the Convention of 1969 of the Organization of African Unity, and the second one is the Cartagena Declaration, which is a non-binding document that includes inside the definition other circumstances which have seriously disturbed public order. This particular part of the definition has been used by several Latin American countries in order to give protection, for example, in the case of Brazil and in the case of Mexico, to people that has suffered the earthquake in Haiti in 2010. And also there were individual cases where the refugee status was given, for example, by Peru, by Panama, and Ecuador to these people. This document, the Cartagena Declaration, I have said that it's not binding, but has been recognized by 15 Latin American states. I have to also add a particular case, the case of Cuba, which doesn't follow the general protection of refugees. Its national law is particularly special, but includes a definition of refugee in its regulation of 1978, which says that refugees include also those foreigners that move to the island because of a cataclysm or a natural disaster. The second part of my presentation regarding the regional non-binding documents. There are two documents I would like to focus my attention. The first one is the guide of the Regional Conference on Migrations. This conference is composed by 11 members, Latin American members, and it includes a guide of 2016, which has special rules on displacement across borders in the case of disasters. Basically, what this document says is that these people shall be protected. It doesn't matter the mechanism. It could be by refugee law, it could be by international human rights law, it could be in other kind of application of the non-refoulement principle. But the most important is to give protection to these people. The second document I would like to mention is the guide of the South American Conference on Migrations of 2019, which says that displaced people and migrants in the case of natural disaster shall be protected. It's a continuation of the first document that I mentioned, but it's focus the special attention on the flexible interpretation that we shall give to any document, international, regional, or even national law, in order to give protection to these people. The third part of my presentation about national law. Well, following these documents, the Cartagena Declaration and these two non-binding regional documents, I have to say that many Latin American countries have included in their national law particular rules on the protection of displaced people because environmental degradation or because climate degradation, or even because of natural disasters. There are two events, circumstances that promoted this movement. The first one was the Hurricane Mitch of 1998, and the second one, probably the most important, was the earthquake in Haiti in 2010. This national law, I can quote, for example, the Argentinian law of 2010, the Bolivian law of 2013, the Mexican law of 2014, of Peru 2015, Ecuador 2016, Guatemala 2016, Brazil 2017. In all cases, a particular protection is given. In some cases, it's given similar protection as asylum, as a refugee, and in other cases is given a special temporal visa in order to permit these people to keep the country in a lawful status up to the moment that they could return to their countries of origin. Basically, when the circumstances that move these people to go outside their countries, basically natural disaster circumstances, has ended. What I can say about this national law, it's true that it's very difficult to summarize all of them, thank you, in 1 minute. But what I can say is that the reason why this law gives protection to these people is founded on humanitarian reasons, and generally is given just a temporal protection. In conclusion, what I can say? Well, I can say that these international law documents and national law, what it's giving basically is a protection to people that is displaced because of environmental reasons, but this protection follows two principles. The first one, the principle of subsidiarity, and the second, the principle of temporality. Yes, 30 seconds. The second element, there is a discretionary character in this protection. So these countries, according to these documents, are not obliged to give protection, but it's true that the non-refoulement principle and the human rights international law protection has to be guaranteed to these people because there are close connection between these two principles and the protection of displaced people. So at the end of the day, and this is my final conclusion, it's quite clear that the non-refoulement principle is going to be consolidated as a custom in Latin America for the protection of displaced people because of environmental disaster. Thank you very much for your attention.
Thank you also to Professor Corti Varela for his presentation and also for keeping the time. And now I will give the floor to Mr. Gonzalo Sanchez Terán. Gonzalo, whenever you want.
Thank you very much. And thank you, Mons, for the invitation. I'll try to use the next 7 minutes to explain why a humanitarian aid worker has been invited to a session on environment and refugees. Every year in the month of June, the United Nations High Commission for Refugees issues a publication that states the figures of forcibly displaced people in the world according to the 1951 Refugee Convention. As you might know, the figure for the last 2 years has been well over 100 million people in the world. In the last 70 years, after that convention was passed, a massive global humanitarian system has been built to respond to that huge displacement of human beings. The idea behind that global humanitarian system with the three big legs of UN agencies, Red Cross movement, and international NGOs was basically to provide life-saving assistance, but also to temporarily keep people protected and assisted until they could go back home. The main tool through which this protection has been used for decades were the refugee camps. This logic that people would stay safe for a short period of time, temporary period of time, until they would go back home, blew up in 2015 during the so-called refugee crisis in Europe, when we saw that over 1 million people tried to gain the continent fleeing a humanitarian crisis. That was clear that the protection that these people needed was not temporary, and that it was false that refugee camps could contain people from trying to move to a better life. After the 2015 crisis, what the OECD countries, the rich countries of the world, did was to double down on the same idea. And since repatriation was clearly not an option, not a significant option for people to go back, now the big emphasis is put on local integration, trying to convince countries that are transit countries, host countries, to reform the law system so that refugees will have, forcibly displaced people, will have more access to job opportunities and to work. The situation has not changed because these people really don't want to stay in Ethiopia, Chad, Guatemala. Most of them, they want to reach countries where they have real job opportunities and real educational opportunities. Why is this significant? Because as this process has moved on, the reality of the climate displacement has kicked in a very strong way. According to the International Displacement Monitoring Center, there are more people now fleeing the world internally because of climate reasons than because of violence. Nobody knows the number of climate refugees, and I say that in inverted commas because of what we've been hearing, because of course they are not legally admitted in other countries. But the reality is that we all know that that figure is going to grow, is enormous right now, and it's going to grow exponentially. And the key question here is, what is going to be the role of the humanitarian sector, of the humanitarian global system in this landscape? In 2018, the Global Refugee Compact was approved. And the Global Refugee Compact, that is the tool that should lead humanitarian response to refugee displacement in the world, is basically focused on local integration of refugees in the countries where they transit, so that they don't transit, so that they stay. And of course, the question for all of us now is, what should be the response to that massive climate displacement? And the answer that the OECD countries, the European Union, the United States, Japan, Australia wants to tell us is, we have to pour money, we've all heard about the Loss and Damage Fund, to receiving countries so that the refugees, the refugees that we don't call refugees, will stay there. The question is that this is replicating a model that has proved to be inadequate, that has proved to be inhuman, but that is being underlined and enhanced in meeting after meeting. On Friday, the Global Refugee Forum closed its session, the second Global Refugee Forum closed its session on Geneva. In that Global Refugee Forum, again, climate was used not as a cause of displacement, because if we acknowledge that climate causes displacement, we have to logically grant protection to the people fleeing climate, but as a problem of adaptations in the countries, where refugees arrive. And the reality is that we are pouring money on those countries, and the reason for that is we just don't want to acknowledge that people fleeing climate disasters, particularly slow onset climate disasters like droughts, those people need the same type of protections that in 1951 people fleeing persecuted were granted. And from a humanitarian perspective, the reality is clear. The 1951 convention was to the 20th century what a climate convention should be to the 21st century. Because as much as violence was the main drive of displacement in the 20th century, climate is and will be the main driving of displacement in the 21st century. And the reason that I'm here is because I strongly believe that academia and the humanitarian global system should join forces to try to break the wall of indifference and insensitiveness on the part of politicians and societies, so that we can reach the goal of providing international protection to human displacement, climate-induced human displacement. Thank you very much.
Thank you very much. And now, please, Professor Fernández-Arribas.
Okay, thank you. And of course, I would like to thank you, Professor Abad and Professor Carballo for this invitation. It's a pleasure to be here. And since I only have 7 minutes, I will keep the time. I will go straight to my topic, which is the EU response to the displacement from the Sahel. And to begin with this, I would like to refer also to the strategic concept adopted in the NATO meeting in Madrid in 2022 that Professor Harry already mentioned. And because in this concept, it was included in this. NATO's southern neighborhood, particularly the Middle East, North Africa, and Sahel regions, faces interconnected security, demographic, economic, and political challenges. These are aggravated by the impact of climate change, fragile institutions, health emergencies, and food insecurity. This situation provides fertile ground for the proliferation of non-state armed groups, including terrorist organizations. And I mentioned this reference because I think that is a good summary of the situation in the Sahel today. So, as you can see, one of the issues referring this concept was climate change as an element that will complicate the security, economic, and political situation in these countries. In this regard, the Sahel is considered one of the most environmentally degraded regions and one of the most vulnerable to climate change. So this situation described regarding climate change in the Sahel is considered to increase the displacement as one of the main options to survive. Even though most of the displacement are intra-regional, the displacement to the European Union also increased. So I think that it is worth to notice what is the response of the European Union to this situation. And something which most of the scholars agree is that in relation to the European Union's approach to the Sahel, is that it has been focused on the securitization of the region, understood as the fight against radicalization and irregular migration, instead of focusing on the political and economic causes of the region's instability and on long-term solutions. This approach has produced, according to some researchers, negative consequences as the increase of insecurity and instability modify smuggling practices and migration routes. This situation has also put migrants' lives at risk and eroded the already fragile relationships between the population and the states. There are many documents, strategies, and policies regarding Africa and the Sahel, but I would like to refer to the European Union strategy in the Sahel 2011-2020, which link development and security, offering maybe a more comprehensive approach to the threats in the Sahel that may produce displacement. In any case, even though this reference, the European Union in that strategy considered again necessary to strengthen the capacity of the countries to fight radicalization and irregular migration, linked security and migration in this strategy. In any case, in 2017, we can observe a new approach with the Alliance for the Sahel that was a political cooperation project. In this project, the priority areas were youth employment and education, rural development, agriculture, food security, climate and energy, governance, and development of basic services. So we can observe in this project or in this cooperation the participation of actors other than the European Union and its member states in the choice of these priority areas, not focusing on areas of special and immediate interest of the European Union, which was, for example, the short-term objective of the reduction of the migratory flows or pressure, but focusing on a long-term strategy based on the roots of the problem of migration. And this line of 2017 seems to be confirmed in 2021 when the European Union adopted the European Union Integrated Strategy for the Sahel, which abandoned the almost exclusive focus on security and opened up to other determining factors in the situation of the instability in the Sahel, identifying, for example, long-term trends that have come to exacerbate the tensions, such as climate change, scarcity of natural resources, or the demographic pressure. And also, in this strategy, they pointing out factors to be addressed beyond security and migration flows. So, regarding the European Union focus on migration in the Sahel, It has been based mainly on funding projects, strategies, agreement, and I'm going to refer, oh, I have a lot of time. So, okay. I'm going to refer, it's enough time. I'm going to refer to three examples of how the European Union had funded this kind of strategies. So the first one is what has been called emergency transit mechanism for the evacuation of vulnerable refugees and asylum seekers from detention in Libya and Niger that was funded by the European Union. A second example is the scheme created in 2017 between the European Union and the International Organization for Migration, also funded by the European Union, that offers voluntary assistance to return sub-Saharan migrants stranded in Libya and in Niger. Other option has been to fund a state to strengthen their borders and control the migration movements in their borders, so making more difficult the displacement that were common in the past in that region. Actually, border crossing has become more dangerous and difficult, with the consequences that the number of migrants using a smuggler has also increased. And finally, I will refer also to the EUCAP Sahel Niger mission, whose mandate was actually enlarged to support the border management and control. Actually, the mandate of this mission was modified to collaborate with the country in the establishment of border control posts in the main migratory routes, and also training those in charge of controlling those or managing those these posts. So in summary, despite the multiplication of initiatives, because there has been a lot of initiatives regarding the Sahel from the European Union perspective, and also regarding migration and security, according to the researchers, it can be concluded that the intervention of the European Union suffered from a lack of coordination and coherence as well. So we need to see, it is needed to have a new approach to the Sahel, which seems to be included in the new strategy, but since now the European Union maybe is focused more on the East, we will have to wait quite a lot in order to know if this new strategy is the correct approach to this situation in the Sahel. I think that I'm in time, so thank you.
Thank you very much, Gloria. We move back to the UN level with Professor Avril Stoffels. Ruth, whenever you want.
Thank you very much. Firstly, of course, I would like to thank the three institutions that host this seminar, and especially I would like to thank Montse that has thought in me for giving this presentation. I'm sure this seminar will be a success because the topics that we have dealt with and because of the persons that have been spoken are very interesting. Professor Susana Borràs told us about the human rights dimension of international displacement. Then Justo told us about who are environmental displacees or refugees. Sanchez Terán told us about final or temporary protection of these people moving from their home to get a better life. And finally, Gloria gave us a specific case of the response of the European Union into the Sahel. I will talk, taking into account all of what has been said previously, I will talk about the special situation of women, but overall of girls displaced by environmental degradation, taking into account that they are a specific group that pose unique challenges. 5 years ago, 41 million people were internally displaced, but nearly half of them were women and girls. Regionally, Africa is the region with highest number of displaced girls. At the UN level, the invisibility of this girl has affected to policy design. As a consequence, they are working on the perception of their specific characteristics. The impact of displacement is different between girls and women. On the one hand, girls are different from women, and boys and girls. Boys are different from girls. So they have specific challenges that need to be known. Displaced girls are often at increased risk of deprivation, insecurity, neglect, and general deterioration of their well-being. Through this presentation, we will shed light on the invisibility of these girls at the UN policy level on their specific problems and capabilities. Displacement dynamics and challenges. The impact of displacement varies significantly between girls and women, and boys and men. This work will underscore the oversight in existing documents regarding the unique challenges and capabilities of girls, highlighting the complexity faced by these girls. If we examine the guiding principles on internal displacement presented by the UN Secretary General Representative in 1998, we can see that there is a deficiency in addressing the needs of girls. The lack of explicit mention of girls in crucial documents, for instance, on displacement and housing and property restitution, further emphasized their oversight as a specific vulnerable group. The absence of detailed information on needs, capabilities, and participation of displaced girls is highlighted, underscoring the resource-intensive nature of data disaggregation. Invisibility and policy formulation. The invisibility of displaced girls complicates the formulation of effective policies and plans. This invisibility impedes the success of measures targeting them, leading to disparities compared to other demographic groups. Addressing this invisibility becomes crucial also in achieving success in projects aimed at the entire population. Therefore, as a consequence, or maybe as both, we must highlight the lack of detailed information on displaced girls. Needs, capabilities, capacities, participation, and willingness are not known by the international community. Even the number, the location, and the age of this displaced person are rarely known. Data disaggregation requires human, technical, and financial resources that many countries affected by internal displacement do not have for the world population, and of course, less for the specific group of girls. Let's see the impact of this kind of displacement on girls. Firstly, let's talk about education. That is the only topic where girls' problems are addressed separately in the documents. Despite the positive impact of displacement on education, especially in displaced camps or in human areas where there is an ample net of school facilities, the truth is that in the opposite situation, it can arise in regions lacking educational infrastructure. But there are other factors that dissuade girls from going to school, especially in secondary. Safety issues in school or in the way to it, stigmatization, traditional gender roles, financial hardship forcing families to prioritize boys' education contribute to this marginalization. the anticipated consequences of what we have just said include hindrance in personal development and limited future opportunities, with projections indicating a hopeless scenario for displaced girls' access to secondary education by 2030. It means that it will be worse in just 5 years. If we speak about early marriages of girls displaced, the needs for family, 2 incomes, and girls' physical security provokes a serious increase of in early marriages. This phenomenon affects adversely to studies, contribute to early pregnancies, contribute to gender violence and mental health issues. We can talk also about a problem of health and nutrition, taking into account that girls often find themselves at the bottom of familiar priority list. So they are the ones that get the medical assistance or the food if there is any other necessity in the family. Unfortunately, the displacement of these girls also leads to increased vulnerability to violence. Lack of protection exposes girls to extreme risks with various actors, including criminals, of course, security members, friends, or even family members perpetrating violence. Unaccompanied girls and those in camps or open communities face ethnic dangers, including trafficking. Girls' socioeconomic resources lag behind those of boys or adults, limiting their access to financial support or help to repair their house, support and hampering recovery from natural degradation. Displaced girls encounter greater difficulties in accessing to employment compared to other displaced individuals. Finally, if women are usually not accepted as speakers and contributors in policy programs, it is necessary to take the perspective of the girls, because they are always outside. But an inclusive participation and contribution in the forum and processes related to disaster and degradation risk reduction, we need to recognize that their uniqueness and address the challenge they face in crucial areas. To sum up, the situation of girls displaced by environmental disaster requires specific attention and coordinated actions. We need to recognize their uniqueness and address the challenges they face in crucial areas such as education, health, and participation in humanitarian and political processes. And this means ceasing to be invisible, using mechanisms disaggregated by sex and age, and then analyzing the existing difference, coupled with indicators sensitive to the needs and capacities of these girls. This is absolutely vital. Moreover, and this is the last thing, addressing discrimination and violence against displaced girls requires a holistic approach encompassing social development policies extended beyond humanitarian responses. Thank you.
Thank you very much, Ruth. Now we move to our last speaker, Mr. Javier Jaramillo. Javier.
Thank you very much, and thank you for the ICEL and the university. Sorry, thanks. And you, thank you. Thank you for ICEL and the university, and well, Montse that's not here right now, but thank you because she was pressing for this subject as she found it interesting for this audience. And Mr. Sanchez-Teran mentioned earlier that figures on climate change will definitely, in refugees, will definitely grow, not in the next years, but right now and soon. And this is a pressing challenge right now. This is a challenge for who? For these organizations, for workers, for country hosts, but also for refugees, of course. How can we deal with these pressing challenges that we have due to the figures that are increasing every year? Well, I'm here to talk about artificial intelligence, or AI. How can we use AI right now for the climate change refugees? Actually, we are using it right now. This is not something new. We will see how, with the systems to preventing disasters and climate change, we have been using AI for the last 10 years. But of course, this is the new trending topic, and this is creating a lot of concerns, because there's opportunities, but there's also risks. So let's focus AI on three main subjects: refugee identification, how can we use AI, status determination, and what I just mentioned, environmental conflict prevention. With the first one, with refugee identification, there's a lot of data that has to be processed right now to identify a possible refugee person. And these people, they need protection and assistance. And the traditional methods that have been used in different refugee camps or worldwide, these are paper-based documentation systems that evidently bring a lot of problems. They are non-efficient, and they're prone also to fraud or errors. So AI seems like a good option to analyze all this information. But is it a solution? Well, AI provides secure and efficient methods, definitely. We can use biometrics to match faces with the ID photos of passports or national IDs. We can use blockchain to protect all the information and to make it transparent of the refugee, to record the refugee identification in a massive way. And this, of course, also helps to avoid fraud or falsification of the documents. And we can use AI with collective intelligence systems, because all these communications, all this information that the refugee community has, well, it helps to feed the machine learning systems and the AI to prevent also potential frauds or cases. But there's concerns, because we see a lot of opportunities, but there's concerns of AI for verification of IDs. There's privacy violation concerns, because they haven't, well, you know how privacy it's in the EU and Spain, but they haven't agreed to give access to this information. Also, there's discrimination, because the machine learning systems and the AI, what they are based upon is information that is given and that is programmed by human beings, and we are biased. And internet is also biased. News outlets, they're biased. So at the end, the machine is also biased. And this is a huge risk with a refugee crisis right now. Surveillance. It's great that we have a system that can monitor or that can assist, for example, different refugee camps in a transnational way. But is that information also being used for surveillance purposes? I think so. And this is a risk, because it's violence against the refugees also. The information is not only biased, but also is precarious. The information, the reliability of the access and the data that is feeding the machines and feeding the AI is not as reliable as we wished they should be. For example, I'm not going to talk about this university, but different universities that are teaching data analysis and data management, they are teaching everyone to process the information. But what about the base? How are we creating in each different country, for example, in Colombia with the Dariem system, all this data and the information that should feed the machines? We're not doing it in a proper way, so at the end, it's not as reliable, the system or the help that it can provide. So with all these concerns, for example, for refugee identification, we should aim to have a transparent AI system where everyone has access, and we can help it to we can help it to improve it. Also, we should aim to have accountability, because it's not like the program failed, the computer failed. These providers of this information, of these systems, they should be accountable for what they're doing, and it should be subject to robust privacy protection systems. And we don't have that yet. The EU is ahead. with the new act for the AI regulation. But right now, worldwide, we don't have robust privacy protection systems. So to fight against this bias or discrimination or the lack of reliability, these systems should be trained on diverse and representative data sets to avoid these biases. And this is not the focus or the aim right now for those that are working with artificial intelligence. They're not working to avoid bias, they're working to have a proper machine that is going to give at least the basics right now. Another option to use AI for a refugee crisis due to climate is for supporting refugee status determination. There's a huge volume of asylum applications, and this overwhelms the traditional systems. And the decision-making process gets a lot of delays, backlogs, and potential errors. So for this refugee status determination, AI can analyze and evaluate massive amount of data. This is where I see a huge benefit of AI right now, because it can process documentary evidence. It can give a value to applications, testimonials, and to the information of the country of origin if it has one. But of course, again, there's concerns. There's the same concerns of bias, and there's the same concerns of the information, of the base of the information that is not there yet. Countries, they don't have it. But there's 1 minute, thank you. Okay, so let me just give you recommendations. Okay, but at least it can give a perspective of where I could give some information for the status determination application process, recommendations and suggestions for the refugee status determination officers. But it should never, never replace the decision-making process of these officers. It's just a recommendation and suggestion, and the machine should never take responsibility or the accountability of the officers, because it will never replace that human-based and human touch that the officers should, and we hope they have. This is very important, to make AI a tool and not the decision-making officer at the end. I think this is it. Thank you.
Thank you. Thank you very much to all the speakers, not only for their insightful and inspiring contributions, but also because I didn't have to use this, which is really frightening. So we have time now for questions from the audience. Let me know if you have any questions. I will take some of them. Yeah. Please introduce yourself before asking the question. And also tell us which speaker do you are addressing.
Francesco Sindico, University of Strathclyde in Glasgow, and IUCN World Commission on Environmental Law. My question is for Gonzalo. Can you just expand a wee bit more the relationship between the loss and damage fund, whatever that may end up being after COP28 Dubai, and your concern not to redo the same mistakes we have done in the past, please?
The loss and damage fund, which is right now stands at around $700 million, it still has to be defined how is it going to be used. But basically the idea is to permit countries to adapt, mitigate, and respond to the humanitarian needs of the people that have suffered from natural disasters or environmental damage related to climate change. The whole idea is that it's putting money on asking communities to stay where the loss and damage has happened. I've worked for the best part of the last 20 years in the Sahel region, from Mali and Guinea-Conakry to Somalia and Ethiopia. And the problem that I have with my job is that I represent a system and a donor base, which is the one putting the money for the loss and damage, that is basically telling the peasants or the neighborhoods, this is the adaptation, or this is the money that you're going to use through insurances, seeds, etc., to stay here. And the question that I ask myself, if I were a Tigrinian peasant, knowing how the pattern of rains are going to evolve in the future, have happened and are going to happen in the future, what would be my preferred choice? To have a mitigation or a loss and damage fund, or to be allowed to move where other people would be possible for me and my family? And the problem is that we are all, and when I say all, it's academia, humanitarian aid sector, etc. We are all part of a system that is telling them, stay. And not only stay, but we are actually going to put money for you to stay because we don't want you here. And the question is, at what point the loss and damage fund, which is, by the way, underfunded, on top of all, becomes an accomplice of political decisions, not humanitarian-led ones.
Thank you. Yeah, of course. Yeah, of course.
My experience is more with small island developing states.
I think we need a mic for those who are online.
We can discuss later, obviously, but my experience is more with small island developing states, especially in the Pacific. And to some extent, they would say the opposite. They would say, whatever happens, I do not want to leave my island. So I just want to say that.
And just if I can go back, at the same time, Tuvalu, as you know, last month signed an agreement with Australia recognizing a yearly number of people that can move through what amounts to a climate refugee scheme to Australia that would empty the island by the year 2015.
We can discuss who pushed that agreement.
And again,
geopolitical Australia.
It's a geopolitical agreement, but at the end of the day is people want to stay. But if you live in Tuvalu, in Kiribati, or in the Marshall Islands, when are you not going to be able? And where are you going to move? Because are you going to move to the cyberspace or to the metaverse? Or are you? And let me be very, very clear. I'm not telling people to move. My only point is that we should establish a mechanism that should allow people legally to move based on environmental deterioration. That's my point.
You know that Hannah Arendt was criticized.
I think we have a question there.
Thank you very much. My name is Edgardo, and I have a question to Javier Jaramillo. I see that the title of your presentation includes the words exploring the benefits of climate change and environmental damage.
Yeah.
But you're right, from what you said, mostly was about data storage, control, and surveillance. So my question is if there's anything or any benefit for the refugees to be with the use of AI in order to help to mitigate or prevent climate change or environmental damage.
Thank you. Yes, definitely. AI can develop sustainable solutions to prevent, definitely, for example, to prevent deforestation, to prevent water scarcity, or all these causes of the environmental changes or climate change that are creating the refugees. Definitely, they will, and they are being used right now. Nonetheless, there's also ethical concerns because at the end, the accountability or the same that I explained before, those that are using or those that are the owners of the programs or the AI, they don't want to be accountable. So at the end, what I have seen at the UN, for example, is that we're not using or we're not implementing systems or programs that are already in place, because no one wants to get accountable of a possible misuse of this technology. But definitely this is the third area that can be used, that the AI has a lot of potential right now, and it's in the prevention of crisis, environmental crisis, for sure. But I didn't have enough time. Sorry.
Okay, more questions? Or maybe,
I wanted just to make a remark because many of the interventions are focused on the refugee concept, the need to expand it, and I was wondering whether we should be focusing more on the rights of migrants in general, I mean, and the free movement of migrants instead of focusing on modifying one document, the Refugee Convention, although others have done it better while following the step of the Geneva Convention. whether we should be moving towards just the free circulation of migrants instead of people, instead of expanding the notion of refugee, which is in the end very limited, no matter what courses we are integrating into it. So it's more of a general question for those that have focused like Justo, Susana, and Gloria.
I'm going to jump in again. I'm really sorry for this, but it's going to be very short. I think that if you look at the political situation and the political trends in Europe and the United States right now, the reality is that migrants that already have very limited rights are not going to get them any bigger. The only hole in the wall that the European Union has built around itself is the asylum-seeking process. It's the 1951 Convention is the only hole in that massive wall. I think that my dream is that we can open up that hole, which is not going to be easy. But I don't think that, do we consider that migrants are going to gain rights in the short future in Europe?
Or worldwide?
Susana, do you want to?
Well, it's why the Toledo decision was very welcome, because we took the Article 33 from the Geneva Convention, even if it's a customary law, we took outside helping states as Italy, France, and Germany to courts, German, French, and Italian courts, to apply this principle for the very first time links to climate change. I would add also that the new rapporteur appointed in last year, if I remember well, is proposing in the first report, is proposing a new agreement to deal with climate migration. But another thing that is quite important is to remember that most people are displaced internally, the numbers, but of course we have people crossing international borders. When you compare the data and figures from the IOM or the United Nations High Commissioner for Refugees, you may compare people fleeing from conflicts and violence and people fleeing from disasters, and are the same people. And it's the thing, it's very difficult to isolate the single cause of climate change, because in the case of Toledo, there were so many land disputes due to climate change shocks. So it's very difficult right now, and it makes difficult to regulate a reality that is very complex. But I fully agree that we need the human rights approach, but also the climate justice approach. Regarding to loss and damage fund.
If I may,
Yeah, of course.
I may say also, it's a very difficult question. What you just said. We're going to have rights for migrants right now. So I'm encouraging nations, and I'm encouraging different type of debates, not to talk only about the rights, but also about the benefits of migration, international migration for the hosts. Colombia has amazing examples of how it was beneficial for the economy with all the migrants that we received from Venezuela. And it wasn't, of course, we had to invest, Colombia had to invest, but with President Duque and with his policies, at the end we had different studies of the benefits that the migrants brought to our economy. Why? Because they are entrepreneurial, because of the higher education, because of the diversification for the economy itself, and it had more benefits than costs. So a different approach should be to start studying more about the benefits of the migration and the receiving migrants for the hosts, instead of talking about rights, because you have to give some sort of incentive for the hosts and for countries to move forward with to talk about rights. First, they must be motivated to talk about this issue.
Justo and Gloria. Justo? Okay.
Yes, I completely agree that the human rights approach probably is the natural way to solve this problem, and the best would be that, for example, last week we have the anniversary of the Universal Human Rights Convention, which includes also the right of free circulation, but never remember that it's included. But in this particular case, I think that if we can prove that a migrant, I'm not talking about environmental degradation itself or natural disaster, I'm talking particularly about climate migrants. If we can prove that this person is moving by a reason directly connected to climate change, so we can apply other principles. For example, the principle of common differentiated responsibility. Susana was probably one of the first person in the Spanish academic community that has talked about this principle as a general principle of international law, and it makes much more easier to fix responsibilities because it is scientifically proved which states are the most responsible for climate change. And so this would be the way to distribute responsibility in much more just way and not that, generally speaking, coffee for everyone, human rights. Thank you very much.
Gloria? Well, yes, regarding migration or asylum, I think that once does not eliminate the other, so we can to enlarge the protection on both of them, working on migration and working on asylum protection. Because actually, as Susana said, the situation is not the same. We are talking about people that forcibly is displaced, and they are forcibly leaving their homes. So it's not like any other kind of migration. I think it's more similar to that of those who have the protection of the Refugee Convention. And this is the point to include these people in the Refugee Convention because their situation are similar. They are forced displaced or people forced to leave their home. And just one note regarding the question regarding the fund, I think that also depends on the region because actually in the Sahel it's quite common to move in order to adapt to the climate. The intra-regional movement were common in the agriculture community or in elders as well. So it's easier for them to move. Probably they will prefer to move instead of being there with those situation and having money for nothing because there are some areas in some regions in which they cannot live even though having that money. Probably in the islands, in the island regions, it's not the same because normally they don't move abroad. But in areas or in regions in which the movement of people is part of their adaptation to climate and part of their life because there are movements, seasonal movements from the country to the cities. There are seasonal movements from north to south. So for them, it's a common or a normal response to climate change. In the moment in which you eliminate or make more difficult the movement, not only affect the capacity of having or looking for some kind of protection, but also their lives as well, because was part of the life of these people. So just that's all.
Okay. Ruth, I don't know if you want to add something. Okay, I think we can close here. It's time to move to our next session, not without thanking once again to the speakers.
Thank you.
Gracias.
Sí. De Bogotá. Pero no lo tengo en radar, lo voy a revisar. Gracias. Pero todos somos.
No, muchísimas gracias. Bueno, me lo habéis puesto muy fácil, la verdad. Pero son pocos 7 minutos, Esto
ICEL leaders and associates on the transformative capacity of law. Well, this panel was going to be introduced by Dr. Ana Martin Beringola, but she was pregnant of 8 months and a half, and these things happens. Yesterday night she was in hospital suffering contractions, and most likely at this time there is a new life in this world. So our best wishes from here. And well, this panel is very promising. It was envisaged as such by Professor Robinson as a sort of window to help to see, know opinions, criteria expressed by senior leaders of ICEL. ICEL is the International Council of Environmental Law, is one of the co-organizers of this event. It's a pioneer organization dealing with environmental law since 1969, when it was created by, at the time, President of the International Court of Justice. And since then, it has been working in the promotion of environmental law in many different fora. Of course, it enjoys consultative status before the United Nations. It has representatives in New York, in Geneva, in Nairobi, and it was recognized as an association in Spain in 2021, and its international secretariat is headquartered in Universidad Carlos III. Well, and this session is focused on the leitmotif of this day, which is the transformative capacity of law. How law can have an incidence on society, on politics, on economics, on the humanitarian aspects. We will have the opportunity to approach two different questions. The first one is the environmental rule of law, which have already, have had the opportunity this morning to be focused on this topic as well, thanks to the interventions of Patricia Cameri-Mombote and the panel in general, the first panel in general. And in second place, the theme will be the United Nations General Assembly right to the environment and national constitutional rights to the environment. The first theme will be approached by Professor Eckhard Rebinder, who is Emeritus Professor at Goethe University, Frankfurt am Main, Germany, and he's a member of the ICEL Board of Governors. While the second theme will be approached by Dr. Victor Tafur. He is adjunct professor at Pace University in New York, and he is the chief administration officer, of ICEL, and the current representative before the United Nations, representative of ICEL. Good morning, or good afternoon, Professor Eckhard Rebinder, and good morning from New York, Dr. Victor Tafur. Are you there? Can you hear us? Can you hear me? Professor Tafur is here, and Professor Rabinder, Eckhard Rabinder, any problem with him? I don't know. I checked my microphone, sorry. There is a message. Well. I apologize. Well, no news. Good news for now. So, Dr. Victor Tafur, could you be available to intervene right now? Yes. Hello. Good morning.
Hello, good morning, good afternoon, good evening for those in the...
Good afternoon. Well, we cannot... Hello, Victor. Happy to see you. We cannot see Professor Eckhard Rebinder. Do you have access?
I think he's there,
Is
but
there?
I cannot see him.
Okay. While we try to solve this technical problem, I think that we could alter the order in the interventions. So maybe we could start listening to you with your presentation about the UN General Assembly right to the environment and national constitutional rights to the environment. The floor is yours.
Thank you very much, Professor Abad, Montserrat, and all of you there at Universidad Carlos III, Puerta de Toledo. I wish I could be there with you, but I'll be happy to share my thoughts and follow later with the video, with the recording, as I haven't had the privilege of hearing the entire session, which have probably been useful for my very short remarks, as some of the topics are connected. Also, Professor Rainbinder's presentation. But I think I can go ahead and give you kind of a brief status of where we are with the recognition of the United Nations General Assembly right to a clean, healthy, and sustainable environment a year and a half ago, and actually it was 2 years ago when the Human Rights Council did it first. So it's a good time to make a first assessment of where we are, and I can do so by asking a couple. Just give me 1 second. A couple very basic questions, which is the questions that were promised when this came as a proposal by several countries, like why now? Although it was more than 50 years waiting, and what was the need to bring it to the forefront? For some, it was very essential, and for other countries, there were some reluctance. So how can we now take a quick view of where we are? I think we can ask two main questions. First, has it served as that catalyst to advance further recognitions and strengthening environmental rights? And as you probably heard, what the environmental rule of law is, I take it as under the traditional definition as the traditional rule of law applied to the environmental world. So I won't get deeper into that. So that first question is, has it served to progress, to advance? And the second question I think we can pose is, has it resulted in further implementation of environmental laws and strengthening those tools? Those are large questions, and it'll be hard to measure it, and it's going to require more time. But I think at this point we can see significant progress, at least in the international front, as it has been recognized by very important frameworks and treaties that will carry into the next decades. For example, it has been reflected in the Global Biodiversity Framework, which now has a human rights-based approach, and it has a chapter on it. So very strongly, the biodiversity framework will carry and will be implemented, taking that focus. And that happened, of course, after the adoption of the UN General Assembly Resolution 76-300. Now, very recently, just last week, the Just Transition Program of Work in Dubai recognizes this right and strengthens in the chapeau, or in the acknowledgements, this principle. I'll just read it quickly for you. It acknowledges that climate change is a common concern of humankind, and the parties should, you probably heard the discussion of how this term evolved, but that was the consensus, to use the should. When taking action to address climate change, respect, promote, and consider the respective obligations on human rights, the right to a clean, healthy, and sustainable environment, the right to health, the right of indigenous peoples, local communities, migrants, children, persons with disabilities, and people in vulnerable situations, and the right to development, as well as gender equality, empowerment of women, and intergenerational equity. So as you see, it's now permeated at least the first level of the structure of the multilateral environmental agreements, the MEA. That's one part. The second part at the international level, of course, is its impact on the international human rights framework. And of course, there it's making even more waves, and it will be reflected very strongly, I would imagine, in the advisory opinions that are coming, that are now being considered on the International Court of Justice, the International Court of Human Rights, and other bodies. There's action at the European Court as well, African, it's all around the globe. So we see first impact at that level. Moving to the other level, the domestic, there it's even more tangible. The national constitutions recognizing the right to a healthy environment in various forms has now increased to at least 161 countries. The last being reported being Canada, actually the place where the UN Special Rapporteur on human rights for the environment comes from, and he's closing. His name, David Boyd, familiar for many of you. And actually he has given a very important report as he has championed this for the last 4 years or even more. He delivered kind of a report, of course, in the Human Rights Council, and then he at the third committee in New York, and his assessment was very much recognizing and giving examples of how it has really increased and beefed, strengthened the implementation on human rights, and not just for individuals and groups, but even countries are using the right to a clean and healthy environment as a shield to protect from lawsuits when the governments are taking action to protect the environment, regulations, and that is now more visible than ever before. Also, following on his report, and this has been documented, he presents this as a bittersweet result, because as you take things a further step up, it has also increased the challenges from companies and you're getting into the field of trade and the environment, which is getting even more complicated as governments are taking more action or following on citizens' provisions, trying to close, for example, of mines, or taking stronger regulation on pollutants. Companies react to that under protection of the free trade, and those are becoming very, very serious concerns. So from that angle, it has become a concern. As my time is limited, I'm going to just finalize with one topic, because I know tomorrow you will hear from another more senior diplomat, ICEL member, that will be touching on this topic and has a more fundamental analysis of what it means and where it's going for. But I will touch on, as a final remark, on the process, which is kind of the focus of most of my work and my academic work as well, which is the environmental diplomacy. This resolution was brought in spurred by 4 main countries: Costa Rica, Slovenia, Switzerland, and Maldives, typically a core group. However, it was expanded to 32 main countries, which is something very hard or very difficult to manage in the UN, especially in the UN General Assembly level. But that made it very useful, because by the time these countries had a solid proposal, it was so well blended and so well balanced that it was very at least easier, or at least it was more of an opportunity to pass it and have it adopted without any votes against it. And that has continued. The countries have met and are doing side events. And in addition to the countries working very collectively, very diverse countries coming together, the coalition of civil society, indigenous people, social movements, and local communities was so strong that on Friday, this last Friday, they got the recognition on the Human Rights Prize. We didn't go to a person this time, it went to a coalition. So the key, and that's the end of my message, is that to follow the implementation, this is just the beginning, and it needs to continue in order to get solid and more tangible results. So with that, I'll close it and I'll pass it to my other colleagues. Thank you.
Thank you very much, Victor. I don't know if Professor Rebinder is now ready. It seems that he has had some technical problems. He could have access to the system, but he had problems. Excuse me, Professor Rebinder, can you hear me? For some reason, the presence of you both is incompatible between each other, because there can be only one person in the screen at a time. So it is necessary that Professor Rebinder say something even when the camera could be not working. This wouldn't be a problem, but it is necessary that you say something. Professor Rebinder, we know that you are there because we have seen that you are connected, but there are problems to see you or to hear you or both. Could you say anything? I suppose that you are mute. You only have to press in the icon of the micro and to remove the mute. Otherwise, it would be impossible for us to listen to you. Please, could you try once more? Any other technical resource that we could use at the moment? Yeah, he told me that he could access, but that he cannot handle the system. But it's very easy. If his camera is on and the micro as well, he shouldn't have any problem. So.
Are you on WhatsApp right now with him?
No, we are talking by email.
Because the next best solution, I know it seems sloppy, would be literally to have a WhatsApp session and have him, augment his voice, the volume of his voice
¿Ya? Entonces, ¿qué le digo? Que se conecte al... Pero no ya se lo he dicho, por correo y por aquí. Que hable, please speak. Sí. Está claro que lo tiene muteado porque le he dicho, please speak. Y también se lo he dicho, tiene correos. No, debe de ser que tiene silenciado el micrófono y no sabe cómo... Please, Professor Ravinder, say anything. Your micro is mute. You only have to press it, or if you want to try through a WhatsApp call, we could amplify here the voice and to get just a summary of your intervention. If not possible, we could postpone this intervention for any other more appropriate moment. I'm sorry. I don't know if there is any reflection or question or thought referring the intervention of Dr. Victor Tafur. Anyone would like to make any remark about that? It's a pity because it is a not wonderful way to finish this session. Yeah, Tria.
Is my voice okay?
Yes, is your voice perfectly okay? Victor, are you listening to Dr. Tria, who is going to pose a question or a reflection for you?
So, yeah, with respect to the idea of there being a right to the environment, right? Either at the constitutional level or the international level. You know, I always wondered, because my background is in legal philosophy, and, you know, I always wonder how we could understand rights whose content mentions things or entities. So right to the environment, right to water, right to food. In other words, it cannot be the case that the content of a right is simply a resource, right, or an entity. There has to be some form, let's say, of action or interaction between the right holder and what is mentioned in the content of the right that makes sense that we are somehow related in a rights way, because it's not just that, you know, we are related to the environment, for example, in terms of justice, because that could also be the issue, right? So distributive justice is a way in which we can start into a relationship with the environment, for example, with respect to the exploitation of resources. But if you want to use the language of rights, the way in which, we interact with that, I mean, there has to be some kind of, I don't know, action that is related to how we relate to the environment. So that's what makes me wonder whether we have, when we have these very short, descriptions of rights, right to environment, right to the rule of law, or, for example, the right to the absence of corruption. I mean, I've seen many descriptions that, imply these kind of situations or resources to which we have rights. And the question is, how can we really make sense of that as a right and not, for example, as a requirement of justice or as a requirement of solidarity or as a requirement of beneficence, for example, right? Thank you so much.
Any others? Should I answer? Sorry.
Any other question?
Montserrat, should I answer now?
Yes.
Yeah, you can.
Yes, please.
The floor is yours, Victor.
Okay. Well, really,
Thank you.
thank you for that question. I think this is just the beginning. It really invites filling up what it really means, and it's going to take decades. But it was just that first level. I think of it in a practical way. The first one is the implementation of those rights that are now there. It will strengthen them. Right to access to information. We have Latin America, the Escazú Agreement. Actually, there's very, very strong laws all around, but they have not been fulfilled. So just access to information, access to pollution, because we do have a lot of rights. The right to water. But what does it mean don't have the right to know, for example, the quality of water, or the right to the sewer problems, to pollution. There's actually some students at Patient University working on having the right to a healthy environment being followed by the right to know the level, the quality of water that you're drinking. Actually, in New York, something that happened not many years ago, but about a decade ago, that made a difference was there's a right to know if the systems of municipalities are failing or not. A right to know, a pollution right to know acts. So not to digress too much, the first one is to implement the rights that we already know have tools to implement. But you're right, at another level, at the highest level, this needs to be fulfilled into the policies and tools at the domestic level, and then even harder at the international level. So fulfilling those gaps are going to require advances in conceptual ways of handling our legal frameworks in connection with business transactions, with information. It will require getting to that next step. I think that's also, it's a challenge, but in a way a response that this is harder, and I think that's the essence of your question. So I thank you for that, and I just added a few remarks as I really capture it, and I value that. I carry that same concern.
Thank you very much.
Any other question or remark?
Okay, Monse?
Yeah. Okay.
I can't interact with the speaker, so I hope he's nodding or at least saying, okay, so we can work on this.
Yes, thank you. We are still trying to make the connection feasible with Professor Rodinger, but it seems that there is no possibility to get so. I sent him my WhatsApp number, and I asked him for his. He's not muted now. Professor Rodinger, would you like to say anything? Hello? Hello?
Hello?
Wow, yeah. Well, hello, good afternoon. You are in Frankfurt. Very...
Well,
Yes? No, you are not in Frankfurt.
I'm sorry.
Sorry?
So, do you hear me? Do you hear me?
Yes, we hear you perfectly. Wherever you are, welcome. And we are here eager to listen to you about environmental rule of law, your reflections on this topic. The floor is yours.
Okay. Thank you. First of all, my apologies, but I had some difficulties, to put it mildly, to handle the whole system, which I have never worked before. Well, the world is under strong ecological stress. It is far from meeting the goals of environmentally sustainable development. From a legal perspective, the question is as to whether the policy of environmental sustainability does not require a much stronger legal foundation that provides more impulses, better evaluation standards, and additional institutional guarantees. This is the objective of the concept of environmental rule of law. The concept was developed in a limited shape by UNEP in 2013. It has then been broadened and refined by the ICEL World Declaration on the Environmental Rule of Law of 2017. This declaration will be the basis of my short presentation. According to the ICEL declaration, and I quote, the environmental rule of law is understood as the legal framework of procedural and substantive rights and obligations that incorporates the principles of ecologically sustainable development in the rule of law. The environmental rule of law makes use of major elements of the traditional rule of law in its parts on governance, and implementation. The declaration emphasizes the importance of the legality of the executive for the protection of the environment, as well as a safeguard against arbitrariness and lack of foreseeability. However, the predominant objective of the declaration is the assurance of ecological sustainability as foundation of future development. Consequently, in contrast to UNEP's concept, substantive requirements play a crucial role in the declaration. The section of the declaration on principles and obligations contains the core elements of the environmental rule of law. The declaration deals with fundamental ecological duties, conventional environmental and new ecological rights, the contents of the ecological dimension of sustainability, and various aspects of justice and equity. Due to time constraints, it's not possible to describe and discuss all these provisions in detail. Some short examples must suffice. Principle 2 posits a fundamental right of humans and other living beings to the conservation and protection and restoration of the health and integrity of ecosystems, as well as an inherent right of nature to exist, thrive, and evolve. Arguably, the ethical and social-cultural ambition of these rights are much stronger than their legal power. In the debate on the rights of nature, quite different concepts have been postulated, from nature's own rights to trusteeship constructs to a mere objective duty of humans to do justice to nature. To hope for a general, rather than just isolated acceptance of the most radical of these concepts is not exactly what one could characterize as realistic. Finally, there's an important practical objection. If the international community, states and society are unwilling or unable to save the earth for the sake of the survival of humankind, it is not very plausible that they could achieve this objective for the sake of nature as such. In various principles, the declaration describes the contents of ecological sustainability. These are core messages of the whole declaration that enrich the existing understanding of the principle of sustainable development and accentuate its ecological dimension. Besides the emphasis of the declaration on resilience, the principle in dubio pro natura is of particular importance. It requires that in case of doubt, decisions shall be taken that most likely favor the protection of the environment. A major specification of this requirement is ecological proportionality. This requirement constitutes a translation from the traditional principle of proportionality, from the protection of the freedom of individuals to that of the environment. Finally, two further principles set forth a prohibition of regression and the requirement of progression, which also enrich the contents of ecological sustainability. In the five principles, the declaration finally deals with various aspects of equity and justice. Primarily, these principles focus on substantive justice, partly procedural justice also is addressed. The idea and underlying these principles is that the environmental rule of law cannot be unilaterally ecological. The ecological claims must also accommodate to social and cultural requirements. In most cases, this will not require trade-offs with the ecological objectives. In some cases, even positive impacts on ecological sustainability might be expected. The Declaration on the Environmental Rule of Law is a remarkable blueprint for the contribution law can theoretically make to achieve ecological sustainability. with its ethical and social cultural valid pathos, and new rights and obligations, new substantive concepts, and new mechanisms of implementation, the Declaration sends important messages for an adjustment of the legal order in support of the transformation of state and society that is needed for safeguarding the ecological foundations of Earth. However, great optimism in this direction would hardly be appropriate. The Declaration contains a compilation of new values, but their real impacts depend on reception and specification by domestic law and national courts, and in particular, voluntary behavior by the social actors. No doubt, social change in the direction of ecological sustainability will occur, but probably not at a pace that is in conformity with needs. In the 6 years after its adoption, the Declaration has not left many threats protection. In a practically anti-ecological economy, and maintain the strong trend towards urbanization and the dominant role of big money. The environmental rule of law is bound to reach limits of effectiveness, which may even turn it to merely symbolic law. The system question, that is the need for a profound transformative change of the whole economy and society, and the consequential question as to the power and limit of environmental law and just juris in this process are not really addressed in the Declaration. In addition, new concerns about international security also run counter to environmental sustainability. So my final conclusion would be a quite limited optimism about the fate of the Declaration. Thank you.
Many thanks to you, Professor Rebinder. Any question, any reflection? Well, I wonder that maybe we could see a sort of imbalance or even a paradox, because while on the one hand the environmental rule of law has advanced in different ways over the last years, for example, in relation to the adoption of right to a healthy environment, or the adoption of specific agreements in a regional framework as the Escazú Agreement. On the other hand, the rule of law in general has retreated, because the democracy in general in different corners of the globe has took a step backwards, and also authoritarianism and populism are increasing. So this is not this is a sort of paradox, or how it is the name. Well, there is another word that it doesn't come to my mind now. Yes, it's an imbalance. It's a contradiction, at least. What do you think about that?
Well, I think there are two problems. One is that is the normal thing about codification. If you start codifying and you have, in the good German tradition, a general part, then you may, of course, give incentives for further development of the legal system, but it's not decisive. The real action, for me, in my opinion, is not on the arena of general principles, but rather the action is on rather specific problems. And if you compare action on climate change, biodiversity loss, and so on, that is much more down to earth than the environmental rule of law. It is a sort of Überbau, but it does not really influence the behavior of society in a way we jurists want it to behave.
Great, very interesting. Well, thank you very much. If there is no other question or remark, we have just to appreciate again your very, very relevant presentations, Dr. Tafur and Professor Rubinder. And we can close the event for today. So thank you very much to all speakers and attendees. See you tomorrow again.